And welcome to this public hearing. This is the public hearing that is arranged to hear two matters. The first matter that we are going to hear submissions from the stakeholders is a matter that involves an inquiry that is initiated by NERSA into the implementation of the maximum pricing by Sasol gas in this case. And this follows a number of concerns that were brought to the energy regulator by various customers. And I would also want to believe that there was also a complaint alleging uniform pricing. We are just having the hearing so that we give all the stakeholders, including Sasol Gas, an opportunity to provide information that will have a bearing to the energy regulator when the energy regulator considers this matter and making a final decision. So all stakeholders will then be given an opportunity in writing, as well as those that opted to utilize the opportunity that we availed today for stakeholders to make oral representation before the energy regulator. So that is the first part of today's hearing. The second part that we are going to deal with today is to look into the impact of the surge in international gas prices, such impact on the South African gas prices. So the energy regulator on the 10th of February 2022 considered a submission, and in that submission there was also a discussion document where that discussion document sets out the context quite clearly that then triggered the intervention by the energy regulator to look into what will happen to the South African gas prices as a result of the developments that we have seen around the world, and given the fact that our own methodology also includes those markets or the prices that are charged on those markets. It was therefore important for the energy regulator to take action in that regard and to look into whether there will be a need for refinement of the methodology, coming up with an interim as well as having a long-term methodology going forward. So we are to hear submissions from stakeholders today with regards to those two issues. So I would like to therefore do the round of introductions. My name is Nomfundo Maseti, and I'm going to be chairing this hearing today, and I'm with my colleagues. And I would like to invite my colleagues to activate their cameras so that I can introduce them in this hearing. Mr. David Mashiane, please mute yourself. I would like to start off with Mr. Muzuvukile Mkhize, who is the full-time regulator member responsible for the petroleum pipelines, and he is also the member of the Piped Gas Subcommittee at NERSA. Good afternoon, Mr. Mkhize, and welcome to this hearing. And also to introduce Mr. Nhlanhla Gumede, who is the full-time regulator member responsible for the regulation of electricity at NERSA. He is also the member of the Piped Gas Subcommittee. Good afternoon, Mr. Gumede. Thank you very much. Members, as I've indicated, we are going to look into these two processes that were initiated by NERSA, and also and listen to the submissions from stakeholders. So just to read out to you the procedures that are going to govern today's hearing. The hearing, first of all, it was advertised in various newspapers, including the Business Day, Sunday Times, independent newspapers, the Beyond, and it was also advertised in the NERSA website. And today's hearing is held and it is governed by the National Energy Regulator Act of 2004. And that act affords an opportunity to affected parties and interested parties to submit their views in writing and also make oral presentations on facts and evidence that will be relevant to the energy regulator in terms of the final decision on the matters that are before the energy regulator for adjudication or final determination. The hearing is, as indicated, is governed by the NERSA rules on public hearings. We are guided by those rules, and I'm going to summarize some of the key points that we need to observe today, of which points are coming out of those rules. The one key point is that all the parties that are going to make presentations today will be allocated at least 40 minutes each. This is because 20 minutes it is for the first part of the hearing that is looking into the pricing behavior, as we indicated, and then the second part is looking at the impact of the international surge in gas prices, as well as the proposed refinements in the existing methodology in order to cushion the South African economy and South African customers from any adverse impact on their part or any detriment that may come as a result of any undue increase in prices. So each of the stakeholders will then be given 40 minutes to touch on those two presentations. It is important to note that only the members of the panel may ask questions to the presenters. However, if there are members of the audience that have joined or observing these procedures, if they have any question and believe that NERSA may ask certain questions of clarity to the presenter, such members of the public may email or send an email on the questions to Mr. Walter Mabunda, to walter.mabunda@nersa.org.za. He is constantly monitoring his emails, and he also forwards those questions to us, and he notifies us. There is a way of notifying us so that we look into those questions and we can decide as the panel how we deal with those questions. Should presenters wish to present information they consider to be confidential, the panel will make a ruling on whether or not we need to close so that we can hear such confidential information, and just make sure that it will only be NERSA employees that are available on the platform to hear such confidential information. Please note that the recording of this hearing is done through the microphones, which will be the official record of this meeting. At this point in time, I would like to just request you to switch your cell phones, and please also your mics must stay muted at all times, and your camera must also be off. Only the camera of the panel members may actually be activated, just to make sure that we proceed smoothly with this hearing. Today we received only two parties or requests from two parties to do presentations. So we have a presentation from IGWA SA, and we have Jaco Human and Jean Meyer, as well as Patrick Smith and Simon Lee. I'm hoping that they will be able to conclude their presentations on both matters within the 40 minutes that is allocated. We will start then with IGWA SA in terms of the request that is before me, that they requested that they start with the presentation. All right, you may unmute yourself, Jaco.
Thank you, Chair.
All right. Can I speak with Jaco, please? And nobody else must have the mic unmuted, please. Jaco, I believe that you're probably going to need assistance. I don't know, but you may indicate. Let me just start off first before we say anything. Do you object taking an oath?
No, Chair.
All right, thank you. May you please raise your right hand? Do you solemnly declare that the facts you are going to present before this panel today will be the truth and the whole truth?
Do, Chair.
I can't hear Jaco.
Do, Chair.
I think that there's a screen that is showing here, and really it's affecting the sound coming from your side in terms of the responses.
Hear me now, Chair?
Yes, I can hear you now. All right. May you please? Okay, no, that is done. Thank you. May you please then state your full name and your designation at IGUA SA for the record.
Okay, my name is Jacob W. Human, and I'm also for the Industrial Gas South Africa.
Sure, Jaco, I'm not sure whether I'm the only person that misses some points of what you are saying. We missed part of what you were saying.
Let me try again, Chair. Apologies.
Yes.
My name is Jacob W. Human, and I'm the Executive Manager for the Industrial Gas User Association of South Africa.
Thank you very much. In terms of your presentation, who else is going to make a presentation today?
Thank you, Chair. I am aptly supported by Advocate John.
You're on mute, Jaco. You've just muted yourself.
I'm aptly supported by Advocate John Meyering and RBB Economics, and we will share the time allotted to us between the three of us, Chair.
All right, thank you very much. May I then just swear them in so that when you start, the presentation can just flow.
I'll call on John.
Thank you, Chair. There seems to be a reverberation. We'll just sort it out.
Yes. Okay. All right. I can't hear you.
Chair, I try again.
Yes. Let me first find out if you have any objections. If you have any objections in taking the oath or do affirmation.
Madam Chair, as a advocate, forgive me, we're just trying to sort out a reverberation that means I can't hear properly, but Madam Chair, can you hear me now?
Yes, I can hear you.
Oh, I can't hear you, but it's being sorted out. I do apologize, Madam Chair. Madam Chair, I try again. I unfortunately can't hear you, Madam Chair, so I think there's still a difficulty.
Can you hear me now?
I can hear you, Madam Chair.
You can hear me? I can also hear you. You may proceed. I was asking if you have any objections in taking the oath or doing an affirmation.
Yes, Madam Chair. As an advocate, I'm not actually a witness in the strict sense of the word. I will be making introductory submissions and submissions of law. So those aren't properly, and it's not proper for me as a member of the bar to take the oath. So on that basis, I cannot take the oath. Madam Chair, again, your sound appears to have gone.
All right, I hear you on that. So if I can just get another presenter in the meantime, so that we can also do the oath.
So, Madam Chair, you have in mind that we swear in all of our presenters who do not object.
I mean, I thought that your submissions will be confined to legal arguments only and will not delve into the facts and evidence. Yes. So that is the reason why you will not take the oath. So with regards to the next presenter, will that be the case?
I believe they will be taking the oath, and Mr. Smith is on the screen now.
Okay, in terms of providing, I believe there will be economic evidence at some point that may be led, so it might not be the case as lawyers would normally do. Okay, all right. Mr. Smith, do you have any objections in taking the oath?
I have no objections, Chair. Thank you.
Thank you very much. May you please raise your right hand? Do you solemnly declare that the facts and evidence that you are going to provide before this panel today will be the truth and the whole truth?
I do.
Thank you very much. May you then state your full name and your designation at RBB Economics for the record.
My name is Patrick Douglas Smith, and I'm a partner at RBB Economics LLP.
Okay, thank you very much. Do we have any other presenter today, or is just
one more?
One more.
Mr. Simon Lee is also on the screen.
Simon
Thank you, Chair.
Okay, Simon, you may unmute yourself.
Good afternoon, Chair.
Okay, may I request Mr. Mayron to mute yourself just to help with the transmission, please. All right. Do you have any objection, Mr. Lee, in taking the oath?
I do not, Chair.
All right. Thank you very much. May you please raise your right hand? Do you solemnly declare that the facts and evidence that you are going to provide before this panel today will be the truth and the whole truth?
I do.
Thank you very much. May you please state your full name and your designation for the record.
My name is Simon Francis Lee, and I'm a senior associate at RBB Economics LLP.
All right, thank you very much. You may start with your presentation, Mr. Human. The time now, I will just say the time is 13:59. You will see how you then allocate the time amongst yourselves. Thank you.
Chair, I will be making a few introductory comments before Mr. Human starts, if that is acceptable to you, Chair.
That is in order. Thanks.
I'm indebted to you, Chair. Chair, by way of introduction, Mr. Himan has mentioned most of our team, and you of course have seen some of our team, those you have sworn in. Might I just for completeness say that the attorney's firm on the brief of which we appear here is Norton Rose Fulbright, South Africa, and that is Ms. Marianne Wagner and Mr. James Donald. Mr. Jeffrey Cron, I see, is also on the call. And then you've met Mr. Himan as well as the team from RBB, which I believe also includes Ms. Jennifer Swart this afternoon. As far as the advocates that represent IGUA SA, those are me. And even though they aren't in attendance this afternoon, the remainder of our team is Advocate Wim Trengo of SC and Advocate Lebogang Paladi. Madam Chair, might I at the outset, and I just have one or two very brief matters of housekeeping to raise for good order. Madam Chair, might I inquire whether it would be appropriate if we were also to record the hearing, not obviously by way of any sort of official recording, but simply for convenience so that we can expeditiously refer to the record. We wouldn't do that if you considered it inappropriate, hence our asking at this juncture whether you would accede to that.
Let me get advice from our in-house legal counsel with regards to the recording, as we only consider our recording as the official recording for the purposes of other parties as well that are attending this hearing. So I would like first to get an initial response from our in-house counsels, legal counsel.
Madam Chair, might I add one footnote? Footnote? It is simply, in our view, the equivalent of taking handwritten notes. It's just more efficient and more accurate. That's the only rationale for it. It certainly is not an official record.
Thank you very much. Mr. Butito Chokwe, can you just advise the members here? You've already heard the reason for the request.
Chair, perhaps we might rely on last. Mr. Chokwe is not here.
Mr. David Mashiane.
Thank you, Chair. I do not see any problem in regarding the request, for as long as it has been acknowledged that the only official record of the recordings will be that of NERSA, and more so that this is a public hearing, so the information is on its own at the public domain. Thank you, Chair.
All right. Yes, that will be that record that you will be using. It will only for your purpose and your purpose only, not for any other stakeholder that is in attendance today or for NERSA's record. The NERSA official record will be the one that is done in terms of the microphones as indicated at the beginning of the hearing. So you may go ahead for your own sake, and that will be the record that will be utilized for your own consumption. Thank you. You may proceed.
We're indebted to you, Chair. Chair, we are very thankful for this opportunity in a collaborative and in a constructive way to engage with the regulator, as IGWASA has on previous occasions. We place on record that certainly the spirit in which we are participating is to assist NERSA, and to the extent that any matter arises, of course, we don't know what is going to be submitted by SASOL most notably, and we reserve the right to provide further input should it be necessitated by anything that arises that is new to us. And that is absolutely in the spirit of assisting NERSA. Chair, Mr. is I'm going to hand over to him in a few seconds to open the substantive part of our presentation to you this afternoon. Might I just place it also on record that owing to the shift of the session from this morning to this afternoon, unfortunately, Mr. Himan will not, in all likelihood, be able to sit through the entirety even of IGWASA SA's presentation international flight later this afternoon. However, to the extent that any questions might need to be directed to him, that he might not be here to answer at the end or at a later stage of this engagement, we have prepared on the basis that in all likelihood Messieurs Smith and Lee would be able to assist, but to the extent that they are not in a position to do so this afternoon, we undertake to provide whatever questions there might be for Mr. Himan after his departure, that those will be answered in short order on paper after the public holiday on Monday as quickly as we possibly can. But Mr. Himan also apologizes for the fact that he will, without announcing his departure, will in fact have to leave the meeting at some point after his presentation. Chair, if those matters are all in order, I respectfully call upon Mr. Himan to open IGWASA's presentation to you this afternoon.
Thank you, Mr. Miereng.
Chair, one further point, just of clarification. while you were introducing the topics that are up for discussion this afternoon, unfortunately, at one point, the sound went out in our venue. But we just place it on record that we are not going to be addressing the first of the two issues. We even though we didn't hear the way in which it was orally set out earlier, we do have it on the notice of the public hearing, the agenda. We won't be addressing the first of the two questions. The question that we will be addressing is, as we understand it, the interim methodology. So we understand the second point to be what are the options in light of the surge to set in place an interim remedy, an interim arrangement. So that frames, Madam Chair, what IGWASA will be addressing you on. And against that background, I then ask Mr. Himan to commence IGWASA's presentation.
Thank you very much. I note all of those things.
Thank you, Chair. Thank you, Mr. Meyering. Chair, thank you for the opportunity. I think we will try and be brief as possible. It is late in the week, and we also understand that you've had other public hearings early in the day. We will be covering a couple of issues, Chair, this afternoon. Myself will do some opening remarks, and we will then provide legal context and then economic context to the issues at hand. And then we will conclude with a very simple position, as you will see, on behalf of industry, what industry sees and what it expects in terms of this review process. Thank you. Next slide. Chair, as you know, the Industrial Gas User Association is a non-profit formal association of large industrial gas users. And,
just hold on, Jaco.
Chair?
Just hold on. I couldn't see the hand. It seems there is a hand that has been raised here. Perhaps it could be, although we would not necessarily. I don't know where it comes from. The barking sound there. There is a hand, and I couldn't see it from the chat who raised the hand. I'm told that it is Mr. Johannes Menkis, I believe is from Sasol. I do know that they will be presenting today as well. So perhaps let me just hear what the issue is, if you don't mind. Just so that we deal with that hand, and then we can proceed with your presentation. Mr. Menkis?
Apologies, Madam Chair, for the interjection. I just, because we will later in the hearing also be making a presentation, I just thought that it's important that with regards to the question about the recording of the proceedings, that we just also put on record that from our point of view as also presenting in the hearing, and based on the fact that it is a hearing of a public nature, we don't have an objection to the additional recording, obviously based on the understanding that the formal record is the recording made by the regulator. We just wanted to put that on record, Madam Chair.
Thank you for clarifying your position and putting it on record. Thank you so much, Mr. Menkis. Mr. Human, may you please then proceed.
Thank you. So just to continue then, so it's a non-profit association, as you know, and which is mainly focused on gas availability, gas policy, and gas pricing. And of course, the key topic and that we're covering today is around the gas pricing elements of it. Next slide, thank you. The Industrial Gas User Association consists of large industrial gas users, Chair, that the names of organizations that you see on this board represent in excess of 80% of the third-party gas use in the country. The issue that we're discussing today is, of course, not only related to these parties or organizations, but we're also talking to probably about another 500 or odd gas users and probably 500,000 plus gas consumers in South Africa. These organizations, Chair, certainly form the backbone of the South African manufacturing sector, and we are currently today faced with certain realities. And these realities play out over the next 2 slides. Thank you. The first reality, Chair, just in summary, is the fact that the current methodology is certainly flawed, and fundamentally so. The first issue that we faced with is that the current methodology, of course, use prices which are relevant in the South African context. And we see this currently playing out in global markets, and also what we faced with in terms of price increases as soon as in the next 10 weeks or so. Secondly, the current methodology, of course, does not assess Sasol gases or the monopoly's actual costs, nor the SA context in general. It exposes gas users to the vagaries of international prices. And of course, the current methodology allows Sasol to earn profits far above its relevant economic costs, including reasonable returns, as allowed for in the Gas Act. IGWASA have certainly consistently warned of the likelihood of these unintended consequences. And these are now coming home, and we are faced with the realities around excessive price increases that will certainly cause harm, and which RBB Economics will highlight later on in our presentation, Chair. We certainly believe that the current methodology is certainly not aligned with the Constitutional Court's instruction to regulate pipe gas prices from 2014. And between Advocate John Meyering and RBB Economics, these elements will also be highlighted in the coming minutes. This is not the first time that we're having these engagements, Chair, as you know, and the gas users have been, and various courts have shared the above basically with NERSA for the last 10 years, and we haven't turned the corner. And hopefully we have, after this review process, that we believe that the pricing methodology will land in a sensible manner. Thank you. Next slide. The key reality that we face, Chair, is that already excessive prices will rise even higher. If you look at this particular graph, what you see there is the historic prices from around about 2014, the blue line around about the 50 Rand a gigajoule level. That is the prices that were historically charged by Sasol on the methodology, the 2013-2014 methodology. The line just above that reflects the prices retrospectively calculated on the current methodology, the one that is currently being reviewed. And that brings us, of course, to the timeline to July 2022. What you see here, Chair, is then an excessive price increase that brings pricing. If you look at the yellow line, that line reflected a forecasted pricing basis pre the Ukraine-Russia crisis that we faced in Europe. The red line above that is the gas price forecast post the Russia-Ukraine crisis. And we expect prices to rise to in excess of 300 Rand a gigajoule mechanistically based on the current methodology and the basis of which Sasol Gas is charging gas users in South Africa. This, Chair, represents an increase of 455% on current levels. And it certainly, in terms of our calculations, will add an economic burden to manufacturers and gas users of 27 billion Rand over the next 3 years. Chair, the manufacturing sector is a large backbone of the South African economy, but all is not well in the sector, we have to add. The sector is in perpetual decline, as we see. From 2000, it represented 20% of GDP in South Africa, and today it only represents 12%. Employment in 2009, the manufacturer sector employed 2.1 million people. Today, it sits at 1.3 million people. This is also faced on a daily basis in the manufacturing space. There's a lack of industrialization or coordinated industrialization policy in South Africa. We're faced with crumbling infrastructure and constrained routes to market through constrained ports. We're also faced with a lack of skills, social insecurity. Last but not least, we are faced with ever-increasing energy cost and availability issues around energy. There's been no more additional gas molecules being made available. We foresee a decline. The gas policy of the state is not aligned to the reality, and we face then, on top of this, with a further burden of 27 billion rand over the next 3 years, purely on unfounded or non-market related basis and simply related to a formula that NERSA has adopted. Chair, in closing, we believe that the runway for NERSA has certainly been lit up over over years now through various inputs in terms of where to land this pricing matter. We have been consistently engaging with NERSA, the regulator, on how we see the right way to regulate prices, the methodologies that should be adopted. We can also refer to the Supreme Courts of Appeal. We can all refer to the Constitutional Court judgment. It is our view, Chair, that in all respect that NERSA is at pains to find a landing strip elsewhere. And we can only see that the only rational outcome, after all, is that of a cost-plus approach. Chair, I would like to conclude and then hand over to my colleagues to take the next part of the legal review and then the economic review. Thank you, Chair.
Thank you very much, Mr. Human. Who's going to do the next part of the presentation?
It will be me, Chair.
All right. Yes, please proceed, Mr. Mayor.
On the next slide, Chair, the one that's coming up, you'll see at the head, this is a response to the consultation document. This is what perhaps colloquially has been called the second consultation document of about the 8th of March. I reiterate that these submissions made orally this afternoon are in respect simply of the interim methodology component of that consultation document, and IGWASA looks forward in due course to make oral submissions in respect of the remainder when it is called for. Madam Chair, this is what you see set out here in a sufficiently small font that we could fit them all in, are the constitutive documents that inform the legal thinking around the issues at play this afternoon, Madam Chair. I don't intend to traverse the law at any great length. I intend to make 3 brief submissions. Firstly, I will alight upon the most important, the central legal principles or precepts that NERSA is to bear in mind with respect in conducting the process that it is. Secondly, I will alight on the most salient findings of the Constitutional Court. Mr. Himan already referred to that. That's, of course, NERSA versus PG Group, the 2019 decision of the Constitutional Court per Campepe J. And then lastly, I will simply refer in passing to the review application that IGWASA has brought in the High Court and which is pending. Madam Chair, against that background, I invite you to take note of 2 provisions in the Gas Act and then 2 of the regulations. And there are going to be no surprises here, Madam Chair. In section 4G of the Gas Act, if I read the main part of 4 and read into G, it reads as follows: the gas regulator must, as appropriate, in accordance with this Act, and then I go to G, regulate prices in terms of section 21(1)(p), and then in the prescribed manner. Madam Chair, if one then turns to 21(1)(p), and again I will read the main part and then run it into P. 21(1) starts: the gas regulator may impose license conditions within the following framework of requirements and limitations. And then P reads: maximum prices for distributors, reticulators, and all classes of consumers must be approved by the gas regulator where there is inadequate competition as contemplated in chapters 2 and 3 of the Competition Act. And then, Madam Chair, if one turns to the gas regulations, it is of course 4.3 and 4.4 that are pertinent. 4.3 reads, the gas regulator must, when approving the maximum prices in accordance with section 21(1)(p) of the Act, do those things that are listed in A to F. So in other words, the prescribed manner that is referred to in 21(1)(p) is then elaborated upon in this regulation. It must be objective, be fair, be non-discriminatory, be transparent, predictable, and include efficiency incentives. And then importantly, because the Constitutional Court also thought it was important, 4.4, maximum prices referred to in sub-regulation 3, the one I've just read, must enable the licensee to recover all efficient and prudently incurred investment and operational costs and make a profit commensurate with its risk. Those, Madam Chair, in our respectful submission, are the salient legal precepts that are to guide the regulator, or to guide NERSA. If one then turns against the background of those provisions to the judgment of the Constitutional Court, and indeed the majority judgment, which, as I've said, is per Campepe J. And I take the forum, Madam Chair, to simply a few paragraphs, and I invite the panel to consider, obviously, the judgment at greater length in the repose of its chambers, but the majority judgment is to be found at paragraphs 1 to 93, and in paragraph 6 to 11. In paragraph 6 to 11, the legal precepts that I've just referred yourself to, Madam Chair, those legal precepts are stated and applied to the, in introductory terms, to the facts of the case before the Constitutional Court. So it's helpful in my respectful submission to see what the Constitutional Court makes of them. Then I invite you, Madam Chair, to take note of paragraph 16. Paragraph 16, and Madam Chair, you will recall the wording of sub-regulation 4.4 when you read the second part of this paragraph, and it reads, the pass-through approach is a simple cost plus percentage method of determining a price. Its use is commensurate with regulation 4.4, which provides that maximum prices must enable the licensee to recover all efficient and prudently incurred investment and operational costs and make a profit commensurate with its risk. So there the Constitutional Court places its imprimatur, Madam Chair, upon the cost plus pass-through method, which you heard with respect Mr. Human already referred to. Then, Madam Chair, not that I'm suggesting there isn't other very rich material in the majority judgment, but for the sake of expedition and for purposes of assisting yourself in the context of this hearing, I then invite Madam Chair, I invite you to turn to paragraph 51, or to make a note of 51 in the Concord majority judgment. And it reads, for purposes of this case, I rely on the absence of consideration of Sasol's marginal costs because it is sufficient evidence of a missing or faulty link between the means and the ends. It is procedural irrationality that signifies the material irrationality. Now that plainly, Madam Chair, is in the context of dealing with whether the decision in the previous case was rational or irrational. But of course, it applies equally to the facts before the forum, the panel this afternoon. And when in due course you hear Mr. Smith and Mr. Lee explain the difficulties with the international benchmarking approach, with respect, it suffers from the very same ill that the majority judgment identifies in paragraph 51 and following of the Constitutional Court judgment. Then at paragraph 62, and this is now in the context of the basket of alternatives approach, but we submit that it is mutatis mutandis, also applicable naturally here. While the basket of alternatives does seem somewhat arbitrary, it may be rationally related to a potential competitive price. Further, any proxy, and this is the important part further, any proxy for the upper bound of an imaginary competitive supply-constrained market would seemingly be arbitrary if not connected to a real-world metric, like the costs of the gas supply. And it's the very same language, with respect, Madam Chair, that you hear in the exposition made by RBB, that there is a disconnect between the international benchmarks in hubs all over the world. There's a disconnect between that and the real world metric in South Africa, which of course, in our respectful submission, is the very reason for the crisis, the surge that has now occurred. Madam Chair, then I invite yourselves to make a note of paragraph 64 to 66 of the judgment. It deals with the application of the rationality principle to the facts. I'm not going to take you to it. And then paragraph 73 and following, where the court deals with this idea of divvying up the economic surplus. So those are, amongst other rich parts of the Constitutional Court judgment. We submit to you, Madam Chair, that those are leading and important findings in the judgment, that against the background of the legal precepts that I alighted upon at the outset, ought to guide NERSA's thinking in this regard. Then thirdly and finally, as far as the legal framework is concerned, Madam Chair, I refer to the application for a review of the latest maximum price decision, the one published in July but dated the 31st of March. And Madam Chair, the three central reasons for IGWASA complaining about that decision are to be found at the first one, at paragraph 120 and following. If you will make a note of that with respect, Madam Chair, 120 and following. The second one is at 138 and following. And the third one is at 153 and following. I trust that the panel does have a copy of these papers. If it is not the case, and it would be convenient, of course, my attorney, Ms. Wagner, will provide it in the course of the afternoon, should that be necessary. But I trust that the panel does, in fact, have access to those papers. And why do I alight upon these three central grounds upon which IGWASA in that application says that the decision is irrational? Not to argue that matter. That matter is to be argued in due course in court. But what I do alight upon, and I'm simply going to use as an example the first of the three grounds. All three of them the panel will have regard to. But the first one echoes the very reasoning of the Constitutional Court, and the heading just on top of paragraph 120 in the founding affidavit is: the use of foreign benchmarking is unreasonable and irrational. And there it is set out why that is the case, and a lot of that reasoning will be echoed when you hear Messieurs Smith and Lee in a minute or so, Madam Chair. But it essentially is that very language of a disconnect that I read to you from the Constitutional Court judgment. It is that disconnect between the hubs selected and the real world metrics. So that very central tenet of the Constitutional Court judgment is directly applicable, and it runs like a golden thread through all three legal submissions I've made: the legal precepts, the reasoning of the Constitutional Court, and the reasoning advanced in Iguasa's review application, which naturally, as it must, relies upon both the letter and the spirit of the Constitutional Court judgment. So that, Madam Chair, we've sought to avoid going into too much detail, but that, Madam Chair, in our respectful submission, provides the legal framework. Of course, the other documents that you see listed on the slide that is currently before you are obviously, and there's no dispute, are relevant, but the three rubrics, legal rubrics that I've just advanced in our respectful submission sets the necessary legal framework. And against that background, Madam Chair, I then invite the gentleman from RBB Economics to turn our gaze from the law to the, or the legal to the economic context.
Thank you.
Thank you, Advocate Mary. Thank you, Chair. Chair, I'll just be very brief. I'm conscious we don't have too much time yet, but we would like to go through some brief economic observations. I'll go first, and my colleague, Mr. Lee, will follow. If we go to the next slide, please. Chair, you've heard lots about the irrationality of the current methodology. I'll be even briefer on that, because we want to get to the need for interim relief, and we think part of that is the irrationality and also the strength of the harm that is going to be caused by that current methodology. But very briefly on this slide, it is based on this international benchmarking approach. We say that's economically irrational and fundamentally flawed because it actually has something in common with the previous basket of alternative methodology. If you were to regulate the maximum price of piped gas based on electricity, we say that's a benchmark that comes outside of the relevant market for the supply of piped gas in South Africa. If the price of electricity goes up, that may not be Sasol's cost, it may not be its price, it may not be anything to do with supply or demand of piped gas in South Africa, but somehow that regulated maximum price will go up. And we said the Supreme Court of Appeal said the Constitutional Court agreed that methodology was irrational. And here we say that the international benchmarking approach is similarly irrational. If something happens in the Ukraine or in the Netherlands or in the United Kingdom, that may have absolutely nothing to do with the supply of piped gas in South Africa. It's entirely economically disconnected from fundamental factors of supply and demand that apply to the supply of piped gas in South Africa. This will echo some of the economics that comes out of legal principles you've heard about, but this is not grounded in assessment of this monopolist's actual costs, nor the South African context. It causes gas users to suffer, and we'll come on to that in a moment, which is an additional motivation for the interim relief. It allows Sasol to earn profits far above and indeed wildly disconnected from its relevant economic costs, which under a cost-plus approach, an alternative which we have strongly endorsed for more than 10 years, that would include a reasonable return. Keep the stock market perfectly happy, cover all your costs, even guarantee of covering your costs and a virtual guarantee of profits, which hardly any companies, even on the stock market, can enjoy. We then say that IGUA SA has consistently warned of the likelihood of these unintended adverse consequences. And again, just refer briefly to our written submissions. This was set out, there were 7 engagements, I think, just on this current methodology, and that's before this consultation process started, so going up till about October, November 2021. So this is not news to you in terms of our submissions. And finally, we say that NERSA simply hasn't adhered to the Constitutional Court's instruction to regulate these pipe gas prices. And I want to very briefly pause here and summarize in four periods or 4 instances of dramatic and substantial abuse of gas customers. The first one actually is the monopoly pricing that existed pre-2014. Under the basket of alternatives approach, that price level, indeed price levels above that, was allowed to persist. Now, the idea was of regulation or rational regulation would be to constrain a monopolist's pricing. That constraint did not occur from 2014. So the first abuse is allowing monopolists to carry on prices at or above the level that it had historically charged when it was not subject to maximum price regulation. The second abuse is that actually those prices got even worse. So prices now are not what they were in 2014, which was the unfettered monopoly price. The third one is what we're mostly talking about today, and I want to be very clear about 3 and 4. The third one is in 2021, there was a massive gas price spike not in South Africa, massive gas cost increase. No, not in South Africa, in Europe. And there are multiple reasons for this. This is pre-Ukraine war and Russia's invasion of Ukraine. This is demand picking up post-COVID. This is perhaps a long winter in 2020, meaning stocks were relatively low in Europe. There was declining production in Europe, and there was some potential undersupply. There was lower wind in Europe, so renewable energy was less available. All of these prompted gas prices to increase dramatically in the period of July, August, September, October, November of 2021. And that's how it will feed into the current methodology from July 2022 in South Africa. Entirely disconnected, but that is the third abuse. And those are the graphs you see now. The fourth abuse is that this current methodology would, if not fixed, would allow a further abuse if and when, I think more likely when than if, the Russia's war on the Ukraine causes further gas price spikes. So not the 2021 problem, a brand new 2022 problem, which is likely to cause European gas prices to go even higher than they are already projected to go. That would be the fourth abuse. And we say all 4 of these abuses, none have been addressed. And I'll hand over to my colleague, Simon Lee, and I'll conclude in a moment.
Thank you very much again, Chair. I'm just going to take us very quickly through this slide, just to add a little bit of context to what Patrick has just said. Again, I'm going to be very brief because I know that NERSA would have seen various iterations of this particular analysis in previous IGUASA submissions. But what I wanted to do, or what we sought to do on this slide, is to compare the maximum prices that are generated by the current methodology to the information that we have on Sasol gases per gigajoule costs. And as I mentioned, NERSA would have seen various versions of this chart in previous IGUASA submissions, but we thought it would nonetheless be useful to unpack a little bit what we are seeing here. So in the first instance, the red line on this chart tracks the maximum price as determined by the current methodology. Now, to construct this data series, we have adopted a similar approach to the one that NERSA adopted to construct Table 4 of the March consultation document. And what I mean by that is we've assessed the HH and the TTF pricing data obtained from the World Bank, as well as the NBP pricing data obtained from Ofgem. But the key difference in this chart is that here we were obviously able to construct this chart a bit later into this year. So what that means is we've been able to use more up-to-date actual pricing data as obtained from the sources that I just mentioned. We also use some forecasted prices that have been provided to us by IGUASA. Now, what can we see on this chart? Well, as Jaco indicated earlier in this presentation, the most recent available data show that the maximum price is set to increase substantially from the current level from the third quarter of this year, reaching levels based on the current data that exceed around 300 Rand per gigajoule. And what we also saw earlier in Mr. Human's part of the presentation is that outlook has changed since earlier on in the year. So as we get closer to the third quarter of this year and more data become available, what we're seeing is that things are only likely to get worse in terms of prices rising higher and higher. So that's the one part of this comparison. The other part is, of course, what we have here as Sasol gas costs. So again, IGUASA has previously made some detailed submissions to NERSA detailing the assessment of the publicly available information that we have on Sasol gas's costs relating to pipe gas. And what we see coming out of this publicly available data is information on two distinct categories of costs. So we have Sasol Gas's production costs per gigajoule, and we have Sasol Gas's internal transfer price, or otherwise known as its acquisition cost per gigajoule. And what we can see from this chart is that the latter category is substantially higher than that former category. Now, in our view, we think that these cost metrics provide important information as regards the competitive price level in the South African context, in the sense that they represent the range of likely prices that would arise under conditions of long-run competitive equilibrium. In other words, these would likely be the highest prices that would be observed in a competitive environment, and they would allow Sasol Gas to recover all prudently incurred costs, including a reasonable return that's commensurate with its risk. Yet what we can see on this chart is that the maximum price, as determined by the current methodology, lies far above each of these cost metrics. And just by way of illustration, we can see that in the current financial year, the excess is in the range of between around 45 Rand per gigajoule and 60 Rand per gigajoule. But looking forward into the upcoming financial year, starting in the third quarter of 2022, when the maximum price is set to jump up considerably, we see that the excess will in turn jump up considerably, reaching between around 285 Rand per gigajoule and 300 Rand per gigajoule. So with that in mind, I'm going to hand back to my colleague Patrick, who will take us to the next slide. Thank you, Chair.
Thank you, Chair. This slide will very briefly summarize that this is an important debate, and the ongoing abuse of gas customers will cause significant economic harm. Really four quick points. Firstly, pipe gas is an important input to many of the manufacturers that Mr. Human introduced earlier. Secondly, many of these members are large industrial manufacturers. They're substantial producers, they're substantial employers. The third point comes back to the abuses that I outlined a few minutes ago, which is that, yes, monopoly prices were an abuse. They cause harm. Yes, the creeping up of monopoly prices cause substantial harm, but the doubling or trebling or potential to double or treble those prices could dramatically exacerbate that harm. And if Russia and Ukraine keep on going hammer and tongs, and those projections get even worse, that fourth abuse, it could be fatal for very many customers. So we again, the fourth point is really, not only do these points reinforce one another, but the international benchmarking approach also creates uncertainty, and that harms incentives for operation, even ongoing operations, investment and employment. So if we go to the next slide, please, I'll quickly talk about some of the types of harm. When we talk about harm, we often think about, oh, well, it might be a short-term thing and then we can sort it out later. What we find in this instance is substantial likelihood of irreparable sorts of harm. Yes, there's the grinding harm of facing monopoly prices for almost a decade into the regulatory regime. But then there are the one-off harms caused by sudden price increases, or the ability to increase prices suddenly, that may cause irreparable harm. They're not just movements of profit or reduction of profit. This causes irreparable harm of the following types. Substantial price increases may cause entire or partial reductions in operations. So shutdown, we're talking bankruptcy, or a portion of overall operations that become no longer viable, say an operation here or a unit there. The second types are cancelling projects, investments, expansions, innovations that otherwise would have been undertaken. You may say, well, maybe when prices come down, we'll try that. Sometimes opportunities pass and those projects are simply not viable in the future when they would have been viable today. The third point we'll make is that sometimes price spikes make time-sensitive opportunities evaporate. So there may be an export market due to some seasonality, or an opportunity to export materials when there's been a local overproduction, or there may be harm to suppliers overseas. They may face force majeure events due to floods or other natural disasters like that, and there may be an opportunity for a South African manufacturer to take up that overseas demand that cannot be met. Now, again, you may think, well, if you don't do it this year, of course, there's always another season next year. But that's not how these markets work. many of these markets require that experience and require that learning by doing before you'll ever get an opportunity to participate in those markets again. Again, a degree of irreparability to the likely harm in these markets. And of course, if this starts to affect individual workers, I think it would be impossible for anyone on this call to suggest that the sort of harm of losing your job to some of the workers that may be involved in these discussions would not be irreparable, at least to some degree for those workers. And the final point I'd say is there's a whole other universe of stakeholders. These are primarily, we think of suppliers, upstream and downstream customers that are going to be affected by any substantial price rise to the gas users. An upstream supplier and a downstream customer, of course, is more difficult to identify. It's more difficult to calibrate, but it doesn't mean that the effect is any less real. Of course, you may never get to meet or hear submissions from a customer that is simply priced out of an opportunity and ceases to exist. Next slide, please. And then the final point we wanted to raise with you is IGWA SA's position on interim methodology. And I do this to summarize the views of everyone that's spoken before and the inputs from them. We say the current methodology will soon permit maximum gas prices to rise far above even what we've said is historical abusive monopoly prices, and a creep up, a further exacerbation in the creeping up of those monopoly prices. We think it is crucial that interim measures prevent this dramatic and further substantial harm, not only to gas users, but to the broader stakeholder sets that I discussed a moment ago. This current methodology, as I mentioned, my sort of 4 types of abuse, was intended to apply from 2014. So there is some logic to say, well, we say it's irrational. We see the irrationality about to be brought to bear from July 2023. Why don't we prevent all of the further abuses, classes 2, 3, and 4 in my taxonomy? So the abuse, there was an abuse from abusive monopoly prices in 2014, and they were allowed to persist irrationally. There's a second abuse from them creeping up. There's a third abuse because of which will happen in July this year, and there may be a fourth abuse if the Russia-Ukraine crisis makes things even worse. However, let's prevent at least the first 3, the last 3 of those, and let's go back to 2014. Say, okay, it's abusive monopoly prices, but let's not let it get any worse. However, we say pragmatically, we live in 2022. We sadly don't live in 2014. Let's just say prices should not get worse than they have been pre this foreseen and this long-known crisis of energy prices in Europe, which will cause, under the international benchmarking approach, will cause the benchmark price to go up very rapidly from July 2022. So we say, let's fix these prices or settle maximum prices at the level that they were generated in the methodology that was applicable for that period, July 21 to June 22, so we avoid this massive spike that you've seen on all the previous graphs. And again, we say this should certainly not include, or we should not build any inflation. I mean, we long ago left behind South African costs. We long ago left behind extreme abuse, far in excess of any cost. We are out of the realm of considering costs. So there certainly should not be any inflationary increase to a wildly abusive price. That is, say, bakes in the first 2 abuses, but at least let's avoid the massive hill that is about to come from July 2022. And next slide, please, just to conclude. Thank you very much, Madam Chair, for your time. Thank you on behalf of all of the speakers. And I'm conscious we're slightly over time. Thank you, and we're happy to take any questions at the appropriate time.
Thank you. Thank you very much. The time is now 14:49. We've started at 13:59. I think it has taken just an hour for the entire presentation. That is fine. We appreciate your time, and we appreciate the effort in trying to bring the facts that you believe are crucial for NERSA to take into consideration in arriving at a final decision on the issue pertaining to NERSA's intervention to refine the methodology in order to prevent any potential harm to the South African customers. So we do appreciate your time. And at this point in time, I would like to invite the members of the regulator that are on the call to ask questions of clarity. If you could kindly take the opportunity, members of the regulator, to get as much clarification as possible, as this is one of the important projects for the energy regulator. Please, you may want to also note that there is a court case. It is important that on some of the documents that I mentioned, one by Mr. Mayren, I was going to point out to him that the document he was referring to, in particular the paragraphs that he pointed out in the paper that was sent by Mr. Human, we certainly do not have it before us as the members of the panel. We rely on the documents that are prepared by NERSA officials, and we can only get involved at the stage where we receive such documents, and we are given certain documents to prepare ourselves for the hearing. And I'm speaking on behalf of my other colleagues here who are not leading the gas regulation matters at NERSA. And unfortunately, all of what they are going to ask from you is solely based on the summary of the issues that were prepared for their consumption and in preparation for this hearing. And I also do not have the copy of the document that you were referring to. And it seems to me that document, and you can clarify later on, that document is the one that Mr. Human may have submitted or is part of the submissions that are before the High Court currently on the review application with regards to the energy regulator decision of approving the maximum gas price for Sasol. And unfortunately, some of those things will have an indirect impact on the methodology that your submissions today have touched on, in terms of you contending that the methodology is rational and it presents or results in unintended consequences. So part of that is what is currently before the court. And maybe members will have to just be careful about that in terms of, can you please mute yourself? As part of our rules that we read out today, we requested that all the participants must keep their mics muted, and only the mic of the panel members and those that are presenting at the time. Can you please mute yourself? So members, if you can just keep that in mind, that there is a case, and that case also touches on the methodology. On the methodology that Gerald, can you please mute everyone except myself? If you can assist me with that, please. So if you can just keep that in mind as you ask questions. I would like the members now to come in, and in your questions, members, if you can also seek some clarity around maybe anything that will be helpful to the regulator in terms of coming up with the methodology, or any refinements that may be required in order to alleviate any possible harm. Mr. Mkhize, you can go first. I can't see the second hand. If I can be assisted by Walter with regards to the second hand, but I will also just give Mr. Gumede as well. I can't hear this. I can't see the second hand. You may start, Mr. Mkhize.
Thanks, Chairperson, and thanks to the presenters for a very insightful presentation. I would start off by maybe seeking to confirm that based on what is in the Constitutional Court decision and what and the presentation is that apparently your preference is on the pass-through approach and a cost-plus approach. Where you say it's simply a cost-plus approach, as you alluded to paragraph 16 of the judgment. I would like to know, do you push for that as the only approach to be used, or you do consider alternatives, and what those alternatives would be on your side. That is one. Two is that if you are looking at the cost plus approach, are you solely looking at it from a point of view in as far as it affects Sasol or relates to Sasol, or you are looking into wider than that to consider the industry as a whole, notwithstanding the fact that Sasol remains the dominant player? So that is the second one linked to that. And then you stated here that there is a disconnect between the international benchmarks and the real world metrics in South Africa. If my question is, if these prices are efficient, or those markets are efficient and quite liquid, wouldn't then the efficiencies there translate into efficiencies in the local sphere? Because we do have examples of international benchmarks, even in the liquid fuels industry, where there's there's an import parity principle that is being used, which then seeks to also drive efficiencies locally. Why are you just saying that these must just be done away with? Is there no way of, say, for example, enhancing these such that that link is created to drive efficiencies? I'm saying this because one would also note that we are globally connected. We're a connected global economy. So if the war the war with the Russia and Ukraine, the issues of demand in Europe, and demand and supply causing gas prices to skyrocket, one would why would those not also factor in the situation where the prices actually have got a negative impact? Those events have got a negative impact on the price, such that the price reduces. So I just want to get just clarity there from your side in terms of what is then expected, because what you would expect when the effect goes it results into the increase in the price, you should also be able to say there could be the price could be going the opposite direction. And so what would you then do in that regard? And then lastly, I would still say that if there are any proposals that you have specifically, you may, because as the chairperson has explained, that we have not been favored with the recent documents as such. So if there are further proposals, I think it will help that you bring those to the fore in terms of how maybe if there's a third proposal to what is already on the table, that will be appreciated. Thank you.
Thank you very much. Mr. Smith, I'm hoping that you were listening attentively and also trying to help you to recall the essence of the questions so that you can assist NERSA in the way that it should navigate through these issues. I hope that you have taken down the questions from Mr. Mkhize. We will allow...
Sorry, Chairperson. Oh, just one thing I didn't mention. Because you mentioned that 50 Rand per gigajoule charged by Sasol prior to regulation in 2014. I just would like to know, because you keep it as a constant, I just want to know if you have considered that price of itself would also be changing over the period, such that it could be going up irrespective. Just want us to factor in the changes in the price per se. Just want to check if you have done that. Thank you. So you can compare apples with apples. Thank you.
Thank you, Mr. Mkiza. So we will now allow, you can come in after we have asked the questions. That's the way that we conduct the hearings. So we'll allow the members of the regulator who are members of the panel today to ask questions so that at least you may have questions that are similar to each other. And perhaps in your response, you can combine and consolidate those questions and answer adequately to all of the questions. Mr. Gumede, may you please come in, and then I'll come after Mr. Gumede. Then you will, Mr. Smith and your colleagues, you may then come in to respond and share the questions or the responses. Mr. Gumede.
Thanks, Chairperson. Apologies, you couldn't see my hand. It was my hand that was up earlier. Chairperson, I've got a few questions for you, Mr. Smith. Actually, something like 6 questions. But as I was listening to all of this, I couldn't help but say, what is the possibility and how do we protect? Because we've got a current case, a current legal case. So to the extent to which some of the views or from some of the questions we may ask, you may want to draw some conclusion. I'm assuming that, whatever the outcome of today is not going to be part of the legal case, because it will, if you like, limit our input. I would like to think, and maybe also just to indicate that whatever questions I may ask and whatever you may infer from my questions, it's important to note that they are not the views of the energy regulator at this stage. I'll be posing questions. I've got a particular starting point, which might be different from the starting point of other members of the regulator, having only joined on the 1st of April 2020. So I'm really asking that I be given that latitude. Otherwise, it will make the asking of the questions extremely difficult on my side, so that it would be known that the views I'm going to be, might be, on the basis of which the questions are predicated, should be seen for what they are. They are not the views of the regulator, but the views of Nhlanhla Gumede, as a member of this panel. So that's the first thing I actually thought I would like to clear up front, so that it would allow me to ask the questions properly. Having said that, and I'm going to start the questions from in the order in which I wrote them. Apologies. I'm hoping that there will still be flow in all of that. Firstly, I had wanted to ask a question that when you make mention of a cost plus approach, a pass through. Firstly, for me, what is not clear is that would you, and I'm basing this on the fact that we are not a natural gas, a country that has got natural gas and therefore will always be importing. That in your view, in looking at this cost plus, in the same manner as we do for the other liquid fuels, is there, in your opinion, a basis that would say we should allow a dominant supply or the current supply to look and say, let's price our costs on the basis of a viable alternative? What I mean by that is that if we are looking and saying the viable alternative in the country is actually importing of LNG into the country and would be imported from particular types of countries and actually imported into a particular port or particular ports, and we look at the costs, at the would-be costs, deemed costs, that would be used to arrive at that. Would you see that as a viable cost plus approach? It is an approach that has been adopted in the pricing of liquid fuels in the country. Or would you see the only cost plus approach that you see would be the actual cost, for instance, in the case of Sasol, of whatever price that it may have had guess whatever price, the price that it may have negotiated with the Mozambique government, and would you see that as the only price? But the question then would be, how sustainable would that, in the event that the gas supply from Mozambique were to dwindle, run out, or whatever, would the alternative not be importation of LNG into the country from a viable location? And would we not look, when we're looking at the cost plus, look at that as an approach? So that is my first question, my general question, in terms of pricing. Having done that, if in the event that you do agree that perhaps the pricing should be one, and would you see that as a viable cost plus, it does not reflect the true costs true Sasol costs, but would reflect the true potential cost of importing into the country on a sustainable basis. So that would be my first question. But as I said, having done that, would you see the relevance of the use of spot prices, spot LNG prices, or would you rather see the use of contract prices? Contract LNG prices, what in terms of your proposal? Thirdly, when you look at when you look at Sasol costs, you mentioned something like the use of Sasol marginal costs. Now, I wasn't sure whether in your proposal of cost plus, if we are looking at just Sasol actual costs that I assume Sasol would need to then declare to the energy regulator. But I wasn't sure when we are looking at those, when we are talking about Sasol marginal cost, are you looking at short-run marginal cost or long-run marginal cost? The next question, you were then saying, okay, the next question I had was one that said, do you, in your opinion, think there is value in looking at the possible, their logic in the use of a viable alternative use of the feedstock to value the product in terms of saying, is there any logic in the use of a viable alternative? Sorry, how do I phrase this? I want to ask the question that says, if I were a particular company and I've got two choices, either sell the gas and and generate some value, or take the gas and use it to generate an alternative product. And then if I then price the value of the gas that I sell based on its alternative use, would you see that as a viable and a logical way of setting the gas price? That is, if I am Sasol, for instance, and I'm saying my alternative is to use this gas to convert in my gas to liquid operation, to convert it into liquid fuels. And if I were to convert it into liquid fuels or chemicals, it would have had this value as a cost input into that process. And therefore use that cost that my sister companies that would have used this gas would be the economic value that they may attach to that gas. Would you see that as a possible viable alternative pricing system, and would you deem that as something that would reflect cost plus and something that perhaps could also be fulfilling the actual requirements of the constitutional court judgment? Now, those are questions from the supply point of view. Now, I actually wanted to flip this to the demand side of it. That, the challenge as the energy regulator is that we deal a lot with suppliers. Ours is to balance the interest of both the users as well as the suppliers. However, we tend to have an understanding, or we tend to have costs from and the value from the and the value of the commodity that we are regulating from the supplier point of view. But we do not have something similar in respect of demand. So, for instance, for the members of ECOWA SA, the question that arises in my head is that, you know, I don't have a feel of the contribution of gas cost into your cost of operation. For instance, is it possible that we are sitting here today and talking about something that is only between 1% and 5% of your costs? Or are we talking about something here in which, in respect of the cost of, I know it would be, if we were to respond today, it would be an average, and considering the confines of the Competitions Act, that perhaps you may not be able to actually disclose your individual members' cost contribution of gas into your operating costs. But for me, I don't know. Is it possible to share, to give us some kind of indicative? I mean, indicative number. What is the percentage of gas into the cash cost of your members' operations? And also, perhaps going forward, would it be possible for your members to share with the regulator, under strict confidential conditions, of course, your demand models, which will show an understanding? For instance, I think, Mr. Smith, as you were talking about opportunities that may emerge and then disappear and what have you, but I couldn't help, as you were talking, but to think, you know, to what extent is gas contributing to your competitiveness, or to the sustainability of these industries, Consol, whatever your members, all of PSG, all of your members? To what extent, what is the role played by gas in your operations? Would that be at all possible to share any of those, such that perhaps it may allow the regulator to then make better informed decisions? Now, the last one, though, is that, having said all of what I've said, I wasn't quite sure I understood what your proposal is in respect of an interim proposed solution. It wasn't clear, as yes, I may have been asking the questions in terms of from my point of view, at least in terms of what the viable, whether the other proposals I was putting forward, whether those could be deemed to be viable cost-plus approaches. But I wasn't quite clear. If maybe you could clarify for me, what actually what is the proposed solution? Apologies, Chair, for taking too long. I thank you.
Thank you, Mr. Gumede. Mr. Smith, I'm not sure if you're still comfortable, but I do have questions, and if you will kindly also include these questions, because maybe they will give you a particular approach in terms of responding to the energy regulator. You know, the first question, and this is also based on the three legal arguments that were made by Mr. Meyering in his submissions, where he indicated that we need to consider the legal framework within which the gas prices are regulated, starting off with Section 4G, which is supposed to be read with Section 21.1p. Now, and also that Section 21.1p is amplified in the regulations in terms of coming up with a systematic and structured methodology, and also the subsection of that Regulation 4, which is Regulation 4 sub 4, it talks about profit that is commensurate with the risk. So those are some of the key legal requirements when it comes to the price of gas, which were alluded to by Mr. Meyering. Now, maybe it is also important that within that framework, we fully understand NERSA's role, and understanding that role, it is also important to understand the approach that NERSA is supposed to take in trying to regulate the gas prices. And in so doing, I would like to invite you to share with us what you view as the role of NERSA, being the economic regulator, in controlling prices or in approving the gas prices in South Africa. What is it that you believe it should be the way that NERSA should approach the regulation of prices? Obviously, that question does not seek to land onto the approach of just saying the cost plus method is the way. But it is important to understand that input, because the cost plus is the input. But we want to understand the objective of regulating these prices. What is it? What is the problem that we seek to address, to deal with, for us to be able to regulate prices? And with the methods that we're coming up with, it is easy to say the pricing formula that is adopted does not yield rational outcomes. But let us also understand, how do we navigate that very same objective of regulating the gas prices? If you can give a due regard to competitive outcomes and to the fact that we are in a situation where we have an immature gas market. Prices, there is no way that we can rely on forces of demand and supply, because we are an immature market in South Africa. And therefore, we are also faced with the monopoly, I agree. And we therefore need, because of this monopoly situation, it is important that any potential existence or potential abuse of market power be constrained by the regulation. Now, in your view, it seems this market power is not constrained if we take the approach that we are taking. I would like to then understand if that framework, so that we all understand what is it that we're seeking to do in terms of Section 21(1)(p). Then the input to say, here's the method. And this method, will it help or will it not help us to deal with market power, to make sure that prices are at efficient levels and affordable levels as required in terms of Section 2J of the Gas Act? Can we be on the same page when it comes to that? If you can share your understanding of how NERSA should ensure competitive outcomes and mimic the outcomes that one will see in a competitive market, because I believe that is the role of the economic regulator, to come up with regulation that will mimic competitive outcomes that we'll see in a competitive market. And if we were to then do that, how do we make sure then we bring that element of seeing what happens in competitive markets? What is your suggestion? Can you bring a suggestion to us? Because we need to come up with a competitive price, a price that is going to mimic outcomes that one will see in a competitive market situation. How do we make sure, even if the approach might be different, but how do we make sure that we bring in that aspect, that element in the consideration of prices, of pricing approvals? How do we bring in the element that will make sure that the energy regulator can be in a position to benchmark and come up with prices that they are certain that the prices that we have in South Africa are prices that one could be able to see in other competitive market conditions? And in making that point sharply and putting an emphasis, I would like also to then draw your attention to the very same judgment of the Constitutional Court on the issue of benchmarking. Not only that it is mentioned in the Constitutional Court judgment, but also the fact that you will know at RPP, and obviously any economist, the role played by any benchmark price and finding an appropriate and competitive benchmark for us to then be able to see whether the role that we are supposed to play as NERSA, whether indeed it can be seen in the end that it meets the competitive price levels that we are striving towards, because there must be something that we are getting into. What is it that we are getting into? Is to get that competitive price level. So I would like to hear you making suggestions on that competitive price level. How do we get there? That is the first thing. And then secondly, also to understand then the role of appropriate competitive benchmark. The Constitutional Court did mention that international benchmarking is an acceptable principle, or is an acceptable international principle. You get it anyway in the economic textbooks anyway. So, however, it also stated that the judgment that in as much as it is an acceptable principle, it does not take away the importance of the regulator considering the price of a dominant or a monopoly supplier. And so that it can enable us to then be able to see whether there is undue surplus, so that that surplus is not surplus that will only be enjoyed by the supplier at the detriment of the customer. So I did not hear your submissions touching on the fact that benchmarking is an acceptable principle. However, the cost consideration must be part of that formula. And so that then the energy regulator must then be able to look into Gerald, can you please just mute everyone and just leave my mic unmuted, and then be able to see if the surplus itself is equitably, that is the word that was used in the judgment, equitably distributed between the supplier and the customer, and also taking into account the element of fairness. I think some of those things, even when we go to the Constitutional Court judgment, and we would want to hear you, how we can also take those pronouncements from the Constitutional Court that just to do the right thing. We do want to hear you on that. Can I? For us, this matter is very important, and I'm sure you wouldn't want to see us being agitated on this matter, because it will give a very bad impression as if the energy regulator is rushing this whole thing and it doesn't want to perhaps give sufficient time to consider this matter. Can I hear you on that? Then perhaps we can come back, because maybe you will lose some of the points. I would like to come back for a second round. And that second round now, we would like to get some assistance here in terms of now the price that could be an appropriate price at the maximum level, not the actual price, at the maximum level, so that there is that sufficient a gap there that not excessive gap, but sufficient gap that will allow us to then allow differential pricing that is allowed in Section 22 on price discrimination first. And the differential pricing is also considered if one looks at the regulations. I think it's regulation 11, but I will check that. Regulation 11 talks about the different classes of customers, where it will look at classes of customers where the first class is the quantities of gas. If you consume 0 to 400, you are small, 400 to 4,000, 4,000 to 40,000, and it goes like that. And then the Section 22 says those classes of customers must be differentiated based on objective differences, and those objective differences are prescribed, being duration of contract, quantities of gas, load profile, interruptible supply, the fifth one being transmission distance. Can I pause there, because this is just at a high level, because the second round I would like now to just get onto the method so that we can be assisted in terms of the refinement, in terms of the methodology itself and the approach.
Madam Chair, I'm going to commence our response to this very rich list of questions just by an attempt at doing some housekeeping, because cognizant that we are far beyond the time allocated for our slot in the program, might I, and I have one or two questions for clarification for you, Chair, but might I, as a general principle, suggest that I ask Mr. Smith to address the most central concerns that have been raised. Of course, there have been economic but also legal points raised. In my respectful and our respectful submission, we will be probably best served if Mr. Smith commences trying to deal with the most salient of the points, and some of the economic points also recurred amongst the questions of some of the questioners, that we do that, but that we then, because it will be absolutely impossible with a necessary degree of nuance to answer all of these questions, even if we settle mid-evening this evening, that our team suggests that Mr. Smith does his best in the next several minutes to address the most important salient of these questions, but that we then submit answers to the remainder in writing as soon as we can. And that is then that suggestion is interlinked with a question as to what, Madam Chair, you envisage when you speak of a second round, because it may well be that if you envisage a second gathering like this, that the suggestion I've made might in fact work meaningfully, in the sense that we do start and we do really want to address these questions, but we do need to answer them fully, because plainly the regulator is desirous of our assistance, which we want to give. So there's that question of clarity, Madam Chair, as to whether my suggestion is an amenable one, and what you have in mind with the second round. I might just make two further points, and that is that whereas we and that it's interwoven with this question about the second round, because we came prepared for submissions on the interim measures. Of course, we made general submissions as a preface to our submissions on the interim methodology, but there's much we would have wanted to and would have addressed to the panel had we been told that it was wider than just the interim methodology. So that's the the third point. And the final point, Madam Chair, is to say that we are in the process of providing to Mr. Mabunda the founding and supplementary founding affidavit in the review application. Of course, that application is no secret. It has been served on NERSA many, many months ago, and with respect, it would be inappropriate of NERSA to close its eyes to that. It's been served on NERSA, it's been served on SASOL, so it's arguably not a matter of public record yet because the matter hasn't been called in open court. But that doesn't mean the regulator won't be taken to have full knowledge of it. So we have, in an attempt to be of assistance to the panel, we are in the process. I can't tell you whether it's been, the send button has been pressed, but it's in the process of happening. And of course, none of the contents of the founding affidavit or supplementary founding affidavit is a matter of any controversy. It's the same arguments in different form, perhaps, that is repeated in our written submissions that we made before this hearing. So those, perhaps I could revert to the question as to what your ladyship's view is on our suggestion as to the way forward, and then just ask what is envisaged by your reference to your mentioning of a second round.
Thank you, Mr. Mayor. The second round, it means that I will allow the members of the regulator to ask further questions. And of course, should you need an opportunity to supplement your responses to those questions once you have taken them down, and you need an opportunity to augment those questions, and we will need to give you the opportunity to do so, so that you can then be able to submit your additional responses to the questions within the next 7 days. So that will be in order if you would like NERSA to give you that opportunity. The deadline that we normally provide, because we would have had the first round of written responses, so we never intend to go beyond 7 days. We normally put that in our own rules if these are questions that emanated from the verbal representations that were done during the hearings. So we'll only provide you 7 days. There's some feedback from your side, if you can perhaps. Yes. So we'll give you 7 days to then respond and supplement your responses to today's questions that arose during the hearing. We do appreciate the fact that you will take time and assist the energy regulator in providing clarification. Now we're coming to the issue.
7 business days. Because yes, there's a holiday on Monday, and it will be very difficult to meet 7 calendar days. Is your understanding that it is 7 business days?
That will be business days, yes. That will be
to you, Madam Chair. Madam Chair, could I just clarify the question that has repeatedly come up, but to which, with respect, I still don't have a clear sense of what your view, Madam Chair, is. But the heading of the second rubric, the second issue today, is the impact of the surge in international gas prices into the South African gas prices interim methodology. Is our understanding that we've stated on the record a number of times already this afternoon correct, that we will be returning for a similar public forum in due course on the actual methodology, but that we are now speaking simply about how to deal with this on an interim basis?
Well, maybe the topic is misleading. If you look at the discussion in my introduction, I spoke about this matter of refining the methodology. And that discussion is based on the submission that was considered by the subcommittee on the 10th of February 2022. That document sets out the observations made by the NERSA team insofar as the surge in gas prices are concerned, and the possible then impact And as a result of that, then the team says, maybe the energy regulator will need to avert any potential adverse effect by refining the methodology. In so doing, the team made some suggestions on various scenarios that can be considered. So what the stakeholders need to consider are the possible scenarios that are included in that document that is out for consultation, of which document says, here are some options of how the methodology can be approached. That is contained in the discussion document. Now, today's hearing is about those options that are contained in the document that was published more than 30 days ago. And we seek the stakeholders then to comment on anything that is contained in that discussion document. So today's hearing is specifically on those options and scenarios that are entailed in that methodology. And stakeholders make proposals and recommendations on what they believe could work and why it could work. So the hearing is about that. And following that, we will then look into the input that were received from the stakeholders, including today's hearing, any oral representations which are in addition to the written input that was made in respect of that discussion document. So all of this input will then enable the energy regulator to make its assessment, then do any refinements based on the input, and then the energy regulator may decide, if it so wishes, if then they want to over-consult, to then perhaps go back to stakeholders to just look to share with the stakeholders as to, based on their input, these are the likely scenarios that are emerging based on the input that was then provided by stakeholders. And then stakeholders may want to then give their final take on that process. So that is the process that we're envisaging, but it is not the normal way that we normally do it, but we may get to that point where we could then incorporate any input that emerged from these processes that we normally undertake, and then we can decide whether we want, again, before we take a decision, go to stakeholders. So that will be the process that we will consider.
Madam Chair, with respect, I still have difficulty understanding. It appears, if I listen to you carefully, that in fact what in the regulator's view is on the table this afternoon is all the different options to review the methodology, the permanent methodology. But in the notice, the undated notice of a week or two ago, it is said, and I read, the extended deadline for submitting comments on the interim methodology is 25 April 2022, and the extended deadline for submitting comments on the review of the permanent methodology is 16 May 2022. So the written submissions on the permanent methodology, as I understand it to be what Madam Chair you are referring to, all the different options, those haven't been submitted yet. So with respect, we can't be making oral submissions on those. So it is, as we understand it, that the process has reached the point where written submissions have been made on the interim methodology, the interim measures, and that's also echoed in the agenda today, the impact of the surge, etc., interim methodology. So we have simply come here in light of the notice and confirmed by the agenda to assist the regulator on the interim methodology. So to the extent that we made more general submissions, we made those as a to back up our respectful and helpful submissions in respect of what to do on an interim basis.
Okay.
But we haven't come here because the notice didn't require us to speak to all these different options in respect of the permanent methodology. And
Okay.
we can't see how we could have been expected to have done that with respect in circumstances where the regulator itself is still awaiting that input on the 16th of May.
All right, thank you, Mr. Mayor. I've got the gist of your concern here, and it may well be that because some of these administrative tasks are not handled by us, and unfortunately, the members of the panel were also not properly informed about the separation of those dates. And I think the sequencing of the processes, it may just be the misunderstanding then, but that is also not an issue. We can still then allow submissions on what is regarded as an interim, and it is just a matter of process. We will then afford another opportunity for the long-term solution. Unfortunately, these things were confusing to us as members of the panel, as you will appreciate, because it is the staff and the managers that are dealing with these kind of things. And now, because ordinarily, we normally have a process where you have this one document. You publish that discussion document inviting stakeholders. Then you set a deadline for written submissions. Then after you have obtained the written submissions, you will then set up a hearing so that you can have oral submissions. It seems, as you've just pointed out, that there's now a separation in terms of the input for the interim and the separate date for the input on the long-term one. So that is fine. We will not disadvantage stakeholders when it comes to that. It is just that, as I responded to you, then that the issue of the other date now on the long-term solution, it's actually separate, and my colleagues as well, they are not privy to that, and I would like to just apologize to them just on that confusion around the dates. So the issue of process will outline it at the end of this of this hearing. If we can just dedicate the time now for the responses to the questions, we will certainly allow stakeholders to provide their written input on the long term. Then we can also have oral submissions on that long term, since now the matter has been split by management in order to deal with those things differently. Thank you.
Indebted to you, Madam Chair, and I invite Mr. Smith, against the background of that elucidation that, Madam Chair, you've given, to address as helpfully as he can, focusing on the questions that relate to the interim methodology predominantly.
Thank you. Sorry. Thank you, Chair. This is a little bit difficult, but I'll do my best to summarize, because what we say about methodology won't change this month, last month, but I certainly defer to all the lawyers. I'm not a lawyer. I'll make some very brief comments. As the discussion has just gone through, we think that, let me start with your comments, Chair, and I will then, again, I really liked Mr. Gomede's introduction, because I don't want to make this personal at all. I think that's unconstructive. Let's try and have a free discussion. So I don't mean to personally attack any, or even ascribe authorship to anyone's particular question, or say, well, you asked this question, therefore you must think like this. But rather, I might label ideas. But please take that in as shorthand for, I label the interesting question that came from Mr. Gomede and the ideas that might support the idea behind a question like that. So it's not an attack on Mr. Gomede, and it's certainly not even attributing ownership of those ideas to him. But let me try and focus very briefly on the interim relief aspect. I know I and other speakers who are representing and speaking on behalf of IGUA SA today, did talk about the irrationality of the methodology, but that was purely focusing on interim relief and the need for interim relief. And I think that's really where our comments should go. I want to briefly talk about, so I'm trying very hard in my mind to separate the two issues so I don't go too far into the longer term issues, because I was asked, why only cost plus? I think let me be very brief on what we say about interim relief. Interim relief, we say, what was the regulated maximum price in the year that will end in June 2022? So from July 2021 to June 2022, whatever that price is. And I'd imagine it's a price like in the 60s. That price, that regulated maximum price, as a matter of interim relief, should not be allowed to go up. So in July 2022, it should not go up. It shouldn't go from 60 to 300. It shouldn't go from 60 to 70 or 80 or 90 or 500. So I had one question, I think it was Mr. Gumede, saying he's not sure what I'd actually said, sorry, it might have been Mr. Mkhize. What is the answer? The answer to interim relief, our suggested answer is, please do not let the regulated maximum price go higher than it was in this current financial year that we're living in, July 2021 to June 2020. More generally, Chair, you said, what is NERSA's role? What do we think about NERSA's role? I'm no lawyer. I'd obviously defer to all of the lawyers involved here. I would say fundamentally, NERSA's role is to regulate prices for gas in a way that is consistent with all of these founding documents. Well, I'll say the few of the founding documents that were pointed out on our slide 9 by Advocate Meyring. So in a way that is consistent with the Gas Act, the Competition Act, the pipe gas regulations, and the jurisprudence, the SCA decision in PG Group v NERSA, and the Constitutional Court decision in PG Group v NERSA, or NERSA v PG Group. That's what I'm instructed NERSA's role is. And when you then say, well, how should they regulate the gas price? Again, defer to all of the lawyers, but there is there are foundational principles in those key documents that I've just highlighted that indicate, how I'm instructed that NERSA should conduct itself. That's what its role is. Hands are not tied to only necessarily have one methodology, but its hands are tied in a sense, in that the statute and the people who wrote those statutes, they've said, this is what NERSA must do, and this is how it must act. This is its role. This is how it must regulate the gas price. And I then have a very quick discussion, again, trying not to get onto the permanent formula, but I must confess, I was quite astounded by some of the ideas that are related to questions that were put to me. I must say, in a country like South Africa, I find it almost unconscionable that I should have to make this little bit of explanation, but I have never, ever seen economic regulators that are so concerned with not only being sympathetic to a monopolist who prices way, way, way above their costs, but also considering ideas or asking questions that are related to ideas that are indulgent of a monopolist, that would encourage a monopolist to set higher prices, that would encourage a monopolist to make even more profit than the stock market would like. The stock market is happy at 30, and we have questions around what's wrong with 50? Why not higher? What's wrong with 80, 90, 150, 300? It's just a complete reversal of what I have seen in almost 20 years of doing this job and what I've seen in hundreds of jurisdictions. It's almost the thoughts are considering the extravagant blessing of a monopolist. And I just find that contrary to the socioeconomic context and the reality in South Africa. But even my little personal philosophies aside, which I think are very well motivated by the socioeconomic context of South Africa, it doesn't matter what I think, because I come back to the point I made a moment ago. NERSA's role, I'm instructed, is to regulate gas prices in a way that's consistent with these documents. And these documents do not say, let's be overly concerned with a monopolist that might want to earn profits way above its cost of capital. They do not say, let's be concerned with a monopolist's profits based on alternative uses or based on how badly someone wants their product. So those documents don't say that. the final general point I'd say is those documents do point to competition. And Chair, in particular, in your comments, you mentioned competition several times. Now, under competition, what happens? Prices are driven down to cost. We'll come back to what exactly cost means, what that is. Under competition, firms don't get to say, well, I'm pricing water today. What are you going to use the water for? Oh, there's a thirsty child. That's one price of R1 per litre. Oh, you're going to wash Anton Rupert's car? No, that's 300 Rand per litre. Firms don't get to do that under competition. They just get to say, someone else is competing with me. They set a price of R1. I've got to set a price of R1.
Mr. Smith,
yes?
Please explain that nature of competition, because you will not get perfect competition. It does not exist in reality, or there is no sector that through competition prices will be driven down to cost. Perfect competition is a proxy, and I don't understand any competition economist that could come to that conclusion. So if you can just highlight which type of competition that you are talking about here, because we do have the basic guidance in economics on which types of competition that we are talking about here, even in the monopoly situation, apart from the perfect competition, to just state that in the perfect competition scenario, where no company is expected to have prices that are above cost, and what is that measure of cost. So let's just put the basic economic principles into context.
Chair, I will try and do that. Chair, under any form of competition, anything better than a monopoly, cost is a consideration, and I'll come to what I exactly mean by cost. I do not mean marginal cost and going right to 1 cent within marginal cost. I mean cost allowing a fair return on capital. So if Sasol's costs of production, and let's not be cute here about some of these questions, are these actual costs? Yes, it's this rand that has left Sasol's bank account and has gone to the government of Mozambique, or that has gone to a steel manufacturer so that it can make pipes, or that has gone to someone who's digging a hole so that they can lay a foundation for its pipes. This is actual money that has gone out. Those are costs. There are marginal costs, there are fixed costs, sunk costs. Then there are capital costs on top of that. There are return on the investments made. All of those costs will make sure that Sasol has not lost a single penny, not a single cent. And then the return on capital would mean that Sasol's shareholders are very happy. They could invest in Tesla or Amazon or Google or Sasol. And they say, actually, I understand the risks of investing in Sasol. And if I get a return commensurate with those risks, I'll happily invest in Sasol. Now, everyone is happy. That would be a total economic cost. So it's the capital cost, the sunk costs necessary to make the business work. It's operating costs, it's the wages, it's all of the costs that business would actually incur. And then it's a return for its providers of capital, in particular equity holders, but also debt holders, if there be any. And that would be a total economic cost. And we would say that under any reasonably effective competition, prices are driven towards that level. Prices are not driven to 5 times that level. They're not driven to double that level. In many markets, in fact, in which the customers of Sasol, the members of IGUA, operate, prices are driven to that level and in many cases below that total economic cost level. They struggle to repay their equity holders and bond holders to the degree that they would like. In some cases, they may have a 5 or 10% margin above those in some years and below that level in other years. So when we say competition, we mean reasonably effective competition. I'm conscious if we go on too long on this, I'll get into the permanent methodology. So I just wanted to make one other general point about this, which is that we always think that competition should be considered within a market. And that would be a product market, and that would also be the geographic dimension of a market. So I don't think it would be at all correct to say, well, the price of gas should be set at the price of an alternative, such as LNG or such as electricity, because that is another market. It is like going to a poor person and saying, here's a loaf of bread. Actually, let me price bread against hamburgers. Because if you're hungry, you could eat bread or you could eat a hamburger. Now, bread is 20 Rand a loaf. A hamburger is 67 if you go to McDonald's. I want to price my bread at 67. That's fair. It's another competitive price. There are lots of people make hamburgers, but of course it is not the right price for that market of bread. And we think that's not anything like what a competitive bread price would be. And if we go back to gas, pricing at the level or with reference to other fuels, other alternatives, very loosely speaking, is just not acceptable. It's not competitive, and it doesn't relate to the market that we're interested in. If we also look in a geographic dimension, the price of a beer in South Africa is about $1. Use this in many illustrations, about 15 Rand, you can get a beer. If you go to the Netherlands, it's about 100 Rand. It would be wrong to say, if there were a monopoly producer of beer in South Africa, dear South African consumers, I want you to pay a, in quotes, competitive price for beer. But that competition only happens in the Netherlands. And there, a competitive price with their higher costs and their regulation and particular tax scenario is 100 Rand a beer. So dear South Africans, you're just going to have to grin and bear it. Competitive prices in the Netherlands are 100 Rand. So therefore, beer in South Africa will be regulated to 100 Rand. We say again, that would obviously be that would be an irrelevant benchmark, an unsuitable benchmark. So my final point on this is just when we say a competitive price, we mean a competitive price in this market. I'm conscious you have in some sense, a difficult job in that you cannot see a competitive price in the South African market because there simply isn't competition. And you've said, and I very much agree, you say it is difficult. You face a monopoly situation. You can't see competitive prices. But we would say, again, all of those foundational texts that we refer back to, I'm instructed they're relevant here, and is it matter of economics? I think that's right. Competition, again, is your lifeline, effectively. Under any reasonably effective competition, competitive prices in that market, competition in that market, will be driven down towards total economic costs, which is actual costs and plus some fair return for a provider of capital, commensurate with risks. Now, with just one final point on actual costs, of course, is that actual cost the monopolist or actual cost of competitive firms? It actually should be the actual cost of competitive firms. For some monopolists can not operate particularly efficiently, and you may find competitive firms may have slightly higher costs, may have slightly lower costs. My personal opinion is that's going to be a rounding error in this context, because if you find the monopolist costs and you find a fair return on capital, you'll be very close to what a competitive price would be. And then arguing about, well, this entrant would be slightly more efficient or less efficient is not really appropriate there. You know, I want to confine to these interim relief questions, and I hope what I've said is already sufficient to show that whatever has happened in the monopoly scenario pre-2014, the basket of alternatives from 2014 to 2021, and then this international benchmarking scenarios, all of those are far in excess of Sasol's costs, as Mr. Lee explained. And all of those we think strongly motivate for some kind of relief. But even all that to one side, what we know the international benchmarking approach does do is it allows this European price spike, which we know happened in 2021, to feed into a South African regulated price that will move it of the order of ×5 up. I mean, a huge spike. And all that we say for interim relief is, please don't let that ×5 spike happen. We say it's irrelevant for South Africa. It is not related to South African demand or supply conditions. But simply, we also say it would be horrific for South African customers. There are various questions. Just one final thing while we stick on the interim relief topic. I think it was Mr. Gumede who said, well, how important is this? You know, what can you do with this? And part of it was going to alternative pricing. But one of his questions was, you know, we need to know how important this is. You did actually already point to part of the answer, which is this is sensitive. it would be very difficult, as you can imagine, not just from a competition law perspective, but for a gas user to stand up and say, look, there's a possibility that this price will cause me X harm, or perhaps bankruptcy or leaving the market. Those are highly confidential matters, and obviously something that we can engage more with under veil of confidentiality. But I think suffice to say, gas is an important cost item for many of these manufacturers. Their margins are very slim. Here, we're not talking 5 times costs. We're talking within 5% of costs for some manufacturers. And a quintupling of gas prices would be horrific for those gas manufacturers. I think at a high level, I've addressed trying to steer this difficult course of just sticking to interim. But of course, I'm also mindful of your time. It's 4 o'clock already.
Yes.
But I'm the questions one by one. I'm just conscious many of them go towards a permanent solution.
Okay. All right. Thank you very much for that. I think the one thing that would like to plead with you about is for you to try and steer away from ascribing any particular question to the energy regulator, or to assume that it is the position and the views of the individual member. That is not the way that we ask questions. I could ask questions in a different way altogether, my line of questioning, but it does not mean that I am actually going to take that particular position, but it is for purposes of trying to get clarification and testing all the things so that we can be able to eliminate things that need to be eliminated. And by the way, public hearings do not even require any quorum, and they are not even considered in terms of the National Energy Regulator Act of 2004 as a decision of the energy regulator. We don't take decisions out of what comes out of the public hearing. What we are here for today is just to hear the submissions. So anything that comes out of this now, as we sit here and after this, it will never be an administrative action at all. It will only be the decisions, and it's clarified in the National Energy Regulator Act that the decisions, the valid decisions, that's the language that is used there, the valid decisions of the energy regulator are those that are taken by the majority of the 9 members. We are not 9 as we're sitting here today. We are only 3 members, and we are simply assisting each other to get as much information as possible. And any line of questioning or the nature of the questions that are raised here do not suggest the position of the regulator or the position of any individual member. So I think the kind of spirit that we'll appreciate from the participants today, including yourself, when we ask certain questions, we ask them because we're trying to get as much as we can and some suggestions, and so that we can test those suggestions and the outcomes of those suggestions. And you did make a point with regards to, and maybe we can take it later, maybe in the other hearing, the one about the product market, because it becomes very important insofar as the potential for LNG imports is concerned in South Africa, and the relevance of looking at the LNG suppliers as being part of the market for gas. I understand that when you broaden it to other fuels, you suggest that we might not come closer to looking into the detriment that the product market purpose is seeking to do, because the product market purpose, it is not a scientific exercise, but it is an exercise that seeks to identify any detriment that we want to deal with, so that then there could be a solution to surrogate that detriment. So that is not the exercise that we're looking at. However, one might actually have a different take when it comes to LNG, if one looks at the product market, because the product market, you don't just look at the properties, the issues, the substitutability, and the product that will actually impose a competitive constraint on the product that you are dealing with. So the key issues, the substitutability and the competitive constraints. in the gist of doing the inquiry on the product market.
Yes, certainly. Chair, just for avoidance of any doubt, I know I had, because I said them, I had tried to say at the start, or I had said at the start of my comments, I don't mean to ascribe any ideas to the authorship of the questions. I'm always grateful for questions because, as you say, then you have a fruitful dialogue. So I don't ascribe that as anyone's position or even the authorship to an individual. It was just to locate where I'd heard the question. But certainly that's very well understood.
Thank you very much. Now, maybe if you can just assist on this interim relief, you made mention, just to make sure that we understand your final position, you made mention of prices that existed between July 2021 until June 2022. Are you suggesting that those should be the prices? And if so, how do we fix that in the interim? In terms of NERSA getting into that kind of a decision. But also, if that is the case, you must also remember that there are other entities or other gas traders in the market, such that then one may not impose one thing for one gas trader and not do the same on the other. So it is also important when you make these suggestions, because some of the the customers are buying from other gas traders. Can you also just assist in how do we then come up with a mechanism that could ensure that prices remain at particular levels at which they may be considered as reasonable? So that's the first part. And also making sure that at least as an independent regulator, that must treat everyone equally and ensure fairness, right? So that how do we then also deal with other traders that are supplying gas to some of the members of IGWA SA? That's the first thing. And also, what is the period for this interim, in your view?
So just to be absolutely clear, I had understood that NERSA sets a maximum price or allows the setting of a maximum price based on a methodology that NERSA has approved. And that happens on as a quarterly basis to it, there's an annual basis to it. So NERSA has a max price in mind for the period July 21 to June 2022. And NERSA knows what that price is because it has already set that maximum. But SASOL must price below that. So our proposal is that NERSA should say that that price that NERSA calculated for July 2021 to June 2022 carries on in time. Whatever that number is, keep it exactly like it is as an interim measure. So if that number comes out as 68.37, make it 68.37 from July 22 to June 23, and so on until we find a methodology, until NERSA were to find a methodology that is a permanent replacement. So whatever that number is, versus 62, 68, 65, 52, whatever that number is, keep it the same come July and until a permanent methodology is derived.
Mr. Smith, you're not helping us in the sense that remember the decision for the duration, the decision that we've made on the maximum price, for instance, for SASOL. Say it is for 2 years, right? From last year. And also it will then automatically adjust that price, right? So if we simply do it in the simplest way, because I was trying to get you to make a reasonable and legally valid mechanism that an energy regulator can use. Now, if you simply say the energy regulator must just say that price that SASOL charged the previous year, and it's going to be very difficult, because how do we go back now and change that very same decision that we have taken last year? And that then becomes a problem, because we cannot change our own decision.
Okay, I must defer to you legally. I must confess, I think that decision was irrational and will hurt consumers and many poor people in South Africa. But I think I don't know what legally is possible. We're thinking economically. The consultation document seemed to have in mind either some new regulation that goes over that. or the replacement of that regulation, or some interim relief that would suspend that decision that you've made. But I certainly defer to everyone else legally. If there is a legal solution that allows the substantive outcome to be that NERSA has a maximum gas price that would happen from July 2022 to June 2023, or as long as it takes to find a replacement methodology, we think that level should be at whatever the current methodology came at for July 2021 to June 2022. But I must defer to the legal folk. I don't know how legally you change your past decision, or how you substitute a new decision that sort of overlays that and said, yes, we agree that in the past, but now we have an interim measure. I can't add to that legally, sorry.
All right, thank you very much. Mr. Mkhize, you had your hand up very quickly, sir, so that we can now move on to the next presenter if after we've had some final concluding remarks from IGWA SA. Let me give Mr. Mkhize first. Mr. Meyer, please let me give
Madam Chair,
Mr.
if I could just answer, well, Mr. Smith there left the legal question open, and might I just to assist you, Madam Chair, make the following submission. The consultation document, the second consultation document, itself traverses, it puts up the notion of different possible interim measures. So in other words, we have to, as members of the public, accept that NERSA has taken its own legal advice such that it has concluded that interim measures are in fact legally sound. It would be improper for us in this forum to give legal advice to the regulator in that respect, the more so because the notice calling for participation from the public itself assumes the legality. In other words, that the regulator has sorted out or will deal with the legalities, but is seeking from the public substantive suggestions as to what might economically be a fair interim measure. And it's in that spirit, in response to the interim measures, if you will, component of the consultation document, that our submissions are to be understood.
I think my question is not understood, Mr. Meyer. All that I was asking is based on the proposed solution that is coming from your side. Mr. Smith is making us a proposed solution for the energy regulator. Can you please mute yourself, please? So Mr. Smith has just made a proposed, can you please unmute yourself? Mr. Smith has made, Mr. Smith has made a proposal. His proposal is this, that the price that was applicable from July 2021 to June 2022, he says it must be the price. That's his proposed solution. My only question is now to just understand how that solution that he's proposing can be implemented by the energy regulator. That's all that I'm asking. Then I'm saying, if he just says the simplest way of doing it, just tell them not to increase that price. They must just continue with that price that is supposed to be charged from July 2021 until 2022. And I'm saying, how do you do that? Can you tell us the way we can then be able, as an independent economic regulator, to make such a decision? Can you just explain to us how do we then, at least a mechanism that will be reasonable and a mechanism that also will not be criticized insofar as other gas traders are concerned? That's all that I'm just, trying to entertain the proposal. It is not to seek any legal advice from yourselves, but to fully understand your own proposal, so that we are not seen to have ignored the inputs that were put before us. It's just the understanding of that proposal. So I'm asking, even that, Mr. Smith, what should then be the period of application of that proposal that you are making? Should it be valid for a year? Should it be valid for 2 years? Is that what you would like to see, so that we understand what you are bringing to us today as part of your input and proposal on the interim measure? Otherwise, then, if you say that you've got nothing else to provide, we will not force you to. But it was simply to say that we want to show that we have considered fully what you have proposed to us, and we fully appreciate and understand it. And we can also be able to, if it's something that is implementable, that it then can be done. That's all.
Madam Chair, I'm going to hand over to Mr. Smith in a moment to give a more and to perhaps elaborate upon what I am due to submit to you. But Madam Chair, we would say that not addressing the legalities, as you've made clear, that's not what the regulator is seeking. The rationale would be that a crisis has arisen. There is a surge, going to be a surge in prices. The price to begin with is an excessive price, and such a crisis of a surge cannot be permitted by the regulator. Again, leaving the legalities aside, and Mr. Smith will deal with the duration and the other aspects of the question.
Thank you so much. All right, can you wrap up then? Can you wrap up, please, in 2 minutes so that we can move on to the next presenter, please?
Certainly, Madam Chair. I don't have much to add. We just wanted to say that of the 4 abuses that have or are likely to happen, we would just suggest capping the 3rd and 4th abuse. So making sure prices do not rise higher than they have currently risen. You've raised many good complications with that, and the legalities are entirely out of my field of expertise, so I can't add anything to those. If there were, as you suggest, a regulation which said, dear Sassel, please don't increase your actual prices. So we're no longer talking about the regulated maximum price. I think that may achieve the same or a similar end, but you've raised a number of complications. So we would suggest the substantive outcome should be that prices do not go up in July 2022. As to duration, we would suggest that's aligned with the replacement of the current methodology with a permanent methodology. I don't know if that will take a year or 2 years or 10. So that's all I can add on duration. Thanks very much, Chair.
Thank you very much. All right, colleagues, thank you very much. Mr. Kumeta, is that a question to Mr. Smith? Maybe for clarification quickly, I can give you the opportunity.
Chairperson, 2 things. Firstly, I wanted to maybe as a question to pose, are as Mr. Smith then saying we should declare force majeure, that says because of whatever problem that may have, external problem that have occurred somewhere else, we declare force majeure and actually have this methodology suspended in terms of whatever approach that we may have approved. That is what he's saying. But I wanted to just make an appeal and a request to them as well, to then say, yes, perhaps today was about interim and we mixed interim and long term. I would really like to still, in writing, if they can still provide us with detailed responses to the questions and proposals that we actually asked of them, so that in the long term, so when we have an engagement, we actually have a view. And my suggestion, I would ask, is that they actually look at how we at the fundamentals that are used in terms of how LPG price is set, the refinery gate price is set, how the basis of the basic fuel price and the reasoning behind that, so that at least when we then next engage, we're not starting from a zero base. So that's going to be my request.
Yes.
Whether I do understand that they may not like the questions we may have asked, neither are the premises that the things that might be premised around that. But we have to understand that, for instance, Sasol it might be a monopoly now, but at some point when you price something, you must price it for sustainability. So those are the kind of questions. It is the basis of what we were asking. Thanks, Jay.
Thank you very much. I guess, Mr. Smith, you got that. If you could kindly then elaborate or augment your responses on the questions that we have asked today. And you may also take liberty to just also bring, that future, the forward-looking approach in the way that you are seeing the gas market going forward, given that the alternative supplier will be an LNG, and from the perspective of a product market, and also for referencing the price. If you can also take those into consideration, and that is not to say that other energy fuels that may not necessarily be the immediate and close substitutes to the natural gas may also be included in that product market. But we also do understand that a product market is not a scientific exercise. It is always based on the preference of customers and also the practicalities pertaining to the substitutability, as well as the competitive constraints and all of the other exercises that the regulator may also undertake in future in order to be informed of what is the substitutability that is practical.
Yes, so we'll certainly get back to you on those. So the first on the current thing, which is interim relief, I'll just reiterate again, I can't say as an economist whether you should declare force majeure, declare the contract null and void, declare the decision irrational. That's all legalities, which I'll certainly ask our legal team if we've got anything to add on that, but I unfortunately can't advise at all on that. On the next questions from Mr. Gumede, I really appreciate your questions and your caution that you've been in the role a relatively short time. I would say I'm fairly confident our written submissions deal with quite a lot of detail on these questions. So yeah, if you can have a look at the written submissions we've already made, we can certainly reconsider some of these aspects. You talk about, the way you regulate other fuels, and markets are different. Gold travels. There is a global gold price. There's not a global pipe gas price. So we'll get into those things. And on the forward looking, sure, if there's a bread shortage, people might have to trade up to hamburgers, but they're not in the same market, and we'll deal again with those. So I know you want more than I don't want to steal more time by going into those now, and also there towards the permanent. But we hear you loud and clear. You need to hear on those issues, and we need to engage on them properly. So really appreciate you highlighting those for us now. Thank you.
Thank you very much for your time, and thank you to Mr. Meyreng, as well as Mr. Lee, and to Mr. Human as well, even if he has already left the call. Thank you very much for your time, and we look forward to your additional.
Might I just hear me? Are you able to hear me, Madam Chair?
You are on mute. You are on mute. You
yes,
can speak
okay.
now.
Thank you, Madam Chair. Just by way of a matter of housekeeping, because the 7 days, the 7 business days that you mentioned previously as being the timeline for the delivery of our answers, that was before the issue of the notice arose. So my respectful submission would be, or suggestion would be, that we answer all the questions that relate to the interim measures issue, which was the topic for today, within 7 business days, and that by the 16th of May, which is the date due for the written submissions on the final methodology, that we, to the extent that we need to augment what we've already delivered by way of answers to all of those questions that relate to the final methodology, that we, in line with all the other market participants that will be making written submissions, that we give you the answers in writing to the questions that really weren't supposed to be ventilated this afternoon, that we do those by the 16th of May. That is our respectful suggestion, and we'd like to hear whether whether, Chair, you are amenable to that.
I'm aligned to that. That will be in order. Thank you.
We're indebted to you, Chair. Thank you
Thank
for
you very much.
The very courteous and constructive hearing we've had this afternoon.
Thank you so much, Mr. Mayor. I appreciate your engagements and your suggestions that you shared with us. Thank you. The next presenter is Sasol Gas Pty Limited, and I have the name of Mr. J.P. Menges to do the presentation on behalf of Sasol Gas.
Good afternoon, Madam Chair. Can you hear me clearly?
Yes, I can hear you. Mr. Menges, today we have allowed you to speak earlier on without being put under oath. We will condone that, but now we'll do the formalities so that everything that you have said, you must have said it under oath. Do you have any objections to taking the oath?
No, I don't have any objections to taking the oath, Madam Chair.
All right, thank you. May you please raise your right hand? Do you solemnly declare that the facts and evidence that you are going to provide before this panel today is the truth and the whole truth?
I confirm as much, Madam Chair.
Thank you very much. May you please then state your full names and your designation at Sasol for the record.
My name is Johannes Petrus Meintjes, and I am the Vice President Legal for the energy business at Sasol. Sasol Gas Pty Limited is managed by Sasol as part of the Sasol energy business, Madam Chair.
Thank you very much. Mr. Meintjes, as you understand, we have two matters that we are hearing today, and I would not want to necessarily dictate how you approach your presentation, but I thought that it will be much more convenient if you could proceed with the matter that we have been discussing for the past 2 hours. If you could start with that and perhaps allow the members of the panel to then engage with your presentation with regards to the matter that we have also discussed for the past 2 hours with ICUA SA. If you could start with that, and then we will then deal with any submissions that you may have with regards to the inquiry into what is termed as uniform pricing. Are you amenable to that proposal?
Yes, Madam Chair. As you can see from the table of contents, the way that we prepared our presentation was to deal with both the matters that is on the program today, namely the consultation document on the uniform pricing matter, as well as the NERSA proposed interim methodology in that order. However, in line with your request for us to flip the order of the two matters around, I can accede to that. Let me just see if I can.
It will be very helpful, and we will flow easily if you were to start with the matter that we have discussed for the past 2.5 hours.
All right. No, that's 100%, Madam Chair. I will then deal with that matter first. Let me just get my bearings then on that. So, yeah, I think from a Sasol Gas point of view, we confirm and we understand that from NERSA's point of view, the mandate that NERSA has in the context of Section 21(1)(p) and Section 4G of the Gas Act to approve maximum prices. That NERSA has consistently confirmed that in dealing with a market where there is inadequate competition, the approach that NERSA follows is to determine an appropriate benchmark to mimic competitive prices in this market, and it's on that basis that that NERSA adopted the 2020 maximum price methodology, and it's also based on that methodology that Sasol Gas then submitted its maximum price application in December 2020, which then led to the 2021 NERSA price decision, which covers the period from 2014 up until 2023, as previously indicated. From our experience and our analysis of the impact of that 2021 NASA price decision, it's clear that the international benchmark prices that were adopted by NASA as part of the 2020 methodology was working quite effective within the period from financial year 2014 up until the current financial year 2022, in which we are, and that is clearly borne out by the fact that the prices in terms of this maximum price decision by NASA in comparison to the maximum prices that applied in the preceding period has been considerably reduced, and that the prices for the 2014 to 22 period under the basket of alternative approach compared with the new maximum prices, the new maximum prices are quite a bit lower than under the previous previous mechanism. We are also aware, and we obviously understand the market movements and the changes in the international gas market that occurred in the 18 to 24 months period after the adoption of the 2020 methodology. And in actual fact, the extraordinary natural circumstances, economic circumstances, and geopolitical circumstances that has led to this impact and the considerable price volatility and higher international gas markets is in fact a confirmation of the competitive nature of these markets and of the appropriateness of the reference to these international competitive market prices as a benchmark to determine appropriate gas prices. Obviously, with regards to the financial year that's upcoming and starts in July 2022 and runs until June 2023, there is a considerable concern from Sasol Gas's side, from NERSA, as well as from customer side with regards to the potential impact that those prices may have, taking into account this price volatility and the increase in the international gas prices that have taken place. And we will come back to an appropriate solution for that concern in a moment. When it comes to the methodology itself, in the methodology document, I think it's paragraph 12 of the methodology, NERSA states that the methodology is subject to regular review every 5 years, or when changes and developments in the gas industry make such a review necessary. And therefore, I think there's full understanding from the licensee's point of view that there is authority for NERSA from time to time to reconsider the methodology to the extent that it may be required. Now, in the consultation document, the process then basically falls into two parts. The first part is that as a result of the immediate and short-term impact of the market movements, there is a suggestion by NERSA that there may be a need to adopt an interim methodology while the longer-term methodology review is not yet completed. And then secondly, NERSA is undertaking as part of this consultation process a review or a possible review to determine whether in the longer term it is necessary to change the methodology or not. And with regards to that longer term review, as the previous speakers have indicated, the due date for submitting comments with regards to that part of the process is the 16th of May, and Sasol Gas will in due course then also make written submissions into that part of the process. As a point of departure, the Sasol Gas position is that in the event that the methodology as it stands at the moment is applied by NERSA within the context of the powers that it has in terms of Section 4G, read with Section 21(1)(p) of the Act, together specifically with a rationality test that is provided for in paragraphs 4 and 8 of the 2020 methodology, NERSA is fully in a position to account and address any relevant market circumstances at any time when it is called upon to make a maximum price decision in terms of the powers that it has in terms of the NERSA Act and the Gas Act. And the reason why we make that submission, Madam Chair, is the fact that in the establishment of the authority of NERSA to consider and approve maximum prices, the Gas Act establishes a wide discretion on the part of NERSA in exercising that power, and in the NERSA Act specifically, in Section 9 of the NERSA Act, it actually obliges and puts an obligation on the regulator to apply its discretion in taking any decision that it is authorized to take in terms of the Gas Act. The Constitutional Court, in its decision, then also provided a guideline that as part of the consideration specifically of maximum prices to be approved for the Sasol gas in the position as a dominant or a monopolist within the current market, that NERSA has to in the approval of maximum prices also achieve an equitable sharing of the excess value for above the cost of the gas. And in that regard, NERSA has specifically introduced the rationality test that I referred to before, and which is set out in detail in paragraph 4 and paragraph 8 of the 2020 methodology. And therefore, it is Sasol Gas's submission that no change or no interim methodology is required to be adopted by NERSA in order to execute its mandate in terms of the Act in approving maximum prices. So to the extent that after the lapsing of the current 2021 maximum price decision at the end of FY23, if Sasol then brings a maximum price application under the 2020 methodology, it's incumbent on the licensee to put all the relevant facts and all of the appropriate applicable circumstances that NERSA has to consider in making a maximum price decision before the regulator. And obviously the regulator has its inherent authority and discretion also to take into account any applicable facts and any applicable circumstances that is required in ultimately getting to a decision on a reasonable and rational maximum price. So from a process point of view, the way that we see the methodology working in considering any future maximum price applications is the three-step process that the methodology provides for. Firstly, determining the price according to the formula in the methodology, to the extent that that price which is yielded by the formula made up of the international benchmark prices does not result in an equitable sharing, then obviously through the application of the rationality test, it is incumbent on NERSA then to temper the price that is yielded by that methodology, and by applying its discretion and taking into account all the relevant facts, to balance the interests between the supplier and the customers in the market, to ultimately then approve a maximum price that is reasonable and rational. And in that regard, the current methodology applied within the statutory framework that is established by both the NERSA Act and the Gas Act is quite sufficient to deal with the current market circumstances that faces NERSA and the market. I think lastly on the question of the interim methodology, one of the burning questions to be addressed is obviously the potential impact of the methodology on the maximum prices for financial year 2023. Now, the consultation document doesn't expressly state how the proposals in the document is aimed by the regulator to effect and to apply to the maximum price that is approved for NERSA, for Sasol Gas in respect of financial year 2023. And in this regard, there is some indication in some of the content of the document that there seems to be an expectation on the part of the regulator that the mere adoption of an interim methodology may have an impact on the decision that is already that has already been taken. In our view, that's not a legally sustainable position. Ex post facto adoption of a revised methodology cannot change the basis on which an existing price decision was made, and it certainly cannot change the content of such a decision. But that doesn't mean that there isn't a solution at the behest of the licensee and the regulator. The 2021 decision is a valid existing decision, and in that circumstance, NERSA, as the administrative decision maker that took the decision, is functus officio to change or to alter the decision. We also know that the decision is subject to a legal review application. However, until the outcome of that decision, and if that legal process ultimately leads to the overturning of the decision remains valid and remains in place. Now, insofar as the decision deals with FY 2022 and FY 23, at the time when the decision was taken, the underlying data on which the maximum prices were to be determined for those two periods were not available yet, and therefore the decision in paragraph 2D1 and 2D2 of the decision included the approval of a method for the adjustment of the maximum prices for those two periods, and that method aligns with the formula that is contained in paragraph 3.1 of the 2020 methodology, or the so-called international benchmark formula. Once this decision was taken by NERSA, as I indicated, then NERSA became functus officio with regards to the content of that decision and is not in a position to amend the decision. However, in terms of the Gas Act, NERSA retains an obligation to monitor and ensure compliance by the licensee with the decision. And in this respect, in FY 2022, the current financial year in which we are, Sasol Gas determined the maximum price as per the method that was approved in paragraph 2D1. We implemented that price in the market, and we also notified NERSA thereof in order to enable the regulator to evaluate and ensure the required compliance with the decision. And similarly, in respect of FY 23, the proposed way forward from Sasol Gas's point of view is that we will similarly determine the prices in accordance with the method that was approved in paragraph 2D2 of the decision, namely with reference to the international benchmark formula. However, the rationality test that is provided for in the methodology still has to be applied to this process or to these prices. So now that the majority of the data has become available during the period which will form the basis of the maximum price to be determined for FY23, what Sasol Gas intends to do is to approach NERSA with the calculation of that maximum price, taking into account the rationality test. And as you will recall, the rationality test takes into account at the floor the acquisition cost of Sasol Gas as the licensee, and as from a ceiling point of view, the Eastern reference LNG price. And ultimately, the maximum price to be implemented in FY23 must, taking into account that rationality test, result in an equitable sharing of the surplus value. And that obviously is something that NERSA, as part of its compliance monitoring, will have to take into account. And from a process point of view, Sasol Gas will therefore approach the regulator with the maximum price determined in accordance with the maximum price decision, also taking into account this rationality test. And once that engagement between Sasol Gas and the licensee is completed, it will then be implemented in the market. I think from Sasol Gas's point of view, it is safe to say that that any expectation to ultimately end up in a situation where a maximum price at the level of 250 or 360 is a maximum price that is determined in accordance with that NERSA decision, taking into account the rationality test, is definitely not the expected outcome of the process, and that there would be a considerable tempering of that price by taking into account the rationality test that the methodology provides for. In taking into account all the relevant factors, just as the impact of the price on the customers is required to be taken into account, it is also important from a supply and from a licensee point of view to take into account that, as has been previously reported, that the gas resources in Mozambique is reaching a stage in its lifetime where the production levels is expected to start tapering off. And in that regard, Sasol is currently in the process of developing considerable developments and considerable capital investment that will be required through Sasol Gas in order to enable the continued maintenance of production at levels that addresses the gas demand within South Africa. And in addition, obviously, as we've previously disclosed, not only to NERSA, but also to the market in a wider sense, Sasol Gas and Sasol, from a wider context, is actively involved in sourcing LNG to also augment the supply of gas into the market. But Madam Chair, with regards to the burning question of the next year as financial year and the maximum price in that regard, as I've indicated, the approach that Sasol Gas will take is to approach NERSA with the maximum price determined in accordance with the existing decision, to enable NERSA to ensure compliance with that decision, taking into account the rationality test as provided for in the methodology, and ultimately, in our view, that will resolve the current concern. With regards to price applications for FY24 and beyond, we intend to bring the maximum price applications in accordance with the 2020 methodology. And again, in doing so, all the relevant factors and the rationality test as provided for in the methodology is together with the statutory discretion at NERSA's disposal in order to ultimately consider those decisions and to approve and determine the appropriate maximum prices for Sasol Gas as a licensee. Madam Chair, I will then jump back to the comments on the implementation of the uniform pricing by Sasol Gas, and I will then quickly deal with the arguments in that regard, and then obviously we can conclude the presentation and go to questions. With regards to the consultation document on the implementation of the uniform pricing by Sasol, this consultation document is part of a NERSA inquiry, which is undertaken by NERSA pursuant to its powers to undertake investigations into the activities of licensees. That is specifically provided for in Section 4D of the Gas Act. Broadly speaking, there's two ways in which these types of investigations can be launched. It can either start as a result of a formal complaint lodged to NERSA, or it can be initiated by NERSA itself. Section 10 of the NERSA Act requires that decisions by NERSA has to be taken within a procedurally fair process and with affected persons having been given the opportunity to submit their views and to present relevant facts and evidence to NERSA. In December 2009, NERSA adopted the pipe gas rules in accordance with Section 34(3) of the Gas Act, and inter alia, this was done in order to comply with the constitutional requirements for its administrative actions, as well as the common law principle of the audi alterum partem, as well as the very particular statutory obligations imposed on NERSA in terms of Section 10 of the NERSA Act. In paragraph 2.8 of this uniform pricing consultation document, NERSA states that the consultation document forms part of a NERSA-initiated inquiry as contemplated in Rule 18.1. So that is an inquiry initiated by NERSA on its own initiative. Rule 18.1 expressly requires that in respect of such a inquiry initiated by NERSA, that the process set out in Rule 19 be followed. Now, in addition to the concern that it would appear that this procedure and process that is prescribed in terms of Rule 19 has not been followed insofar that this inquiry by NERSA into the uniform pricing by Sasol Gas is an inquiry initiated on NERSA's own initiative. In the introduction to the public hearing today, there was some reference made to a possible formal complaint that was made. Now, Sasol is not aware of such a formal complaint. However, if such a formal complaint is part of the factual circumstances that led to this inquiry, then in addition to the concern that the requirements detailed in Rule 19.3 to 19.6 have not been adhered to by NERSA prior to the publication of the consultation document, it might also mean that if there is indeed such a formal complaint before NERSA, that in that process the requirements of Rule 19.1 and Rule 19.2 may also not have been complied with by NERSA. Now, this is obviously a procedural issue. However, if one looks at paragraph 4.1 of the consultation document, NERSA sets out certain preliminary conclusions, and that preliminary conclusions include the conclusion that Sasol Gas may potentially have contravened certain provisions of the Gas Act. Sasol Gas denies any such alleged contravention of the Gas Act. I think it's important that we put that on the record. But it's also important to note that in its capacity as a licensee facing severe prejudice from being denied its rights as provided for in the procedure set out in Rule 19, Sasol Gas respectfully suggests and requests that NERSA withdraw this consultation document and then start the process anew and correctly follow the procedural process as set out in the rules that apply, both in terms of the Gas Act, the applicable rules adopted by NERSA, as well as the general legal requirements that is provided for in the NERSA Act and the Constitution. This is not only a procedural concern on the part of the licensee, because on our evaluation of the consultation document, and we have submitted some written submission to NERSA in response to this document, but in our analysis of the content of the document, our conclusion is that the analysis and conclusions on which the concerns that NERSA is attempting to address through this consultation document is based on factually incorrect conclusions. So in terms of the consultation document, NERSA indicates that the actual prices implemented by Sasol Gas as part of the uniform price have increased, and as a result of the increase, there's a whole range of conclusions that NERSA then draws as part of the consultation document. The actual fact is, however, that if one compares the prices that would have applied under the previous basket of alternative approach, and you compare that with the uniform price that was applied by Sasol for this FY22 period, the factual situation is actually quite the contrary, and the price have reduced substantially. Individual customer pricing is obviously a confidential matter, and we would not, as part of this public hearing, wish to enter into a discussion about individual price levels. However, in the event that NERSA reviews the process and restart the process based on the correct procedural requirements as is set out in the rules that I've referred to, obviously Sasol would then on a confidential basis be able to submit the appropriate information to NERSA in order to rectify the conclusions and hopefully to a large extent address the concerns that is the subject of this consultation document. I think a last point just to be made in this regard is the fact that in the consultation document, NERSA does refer to the retrospective impact of the new maximum prices as approved in the 2021 maximum price decision, as well as the potential impact thereof, specifically in the context of the remarks in the Constitutional Court decision and the reasons for decision by NERSA when it adopted the maximum price decision around expectations about refunds to be made by Sasol Gas to its customers. And in this regard, we would like to just confirm to the regulator that within the coming week or two, Sasol Gas will be approaching on an individual basis the affected customers in relation to the retrospective impact for the period from FY 2014 up to 31 August when the new actual price was implemented by Sasol Gas. And in engaging with customers in this regard, we will also from the licensee side keep NERSA updated on the progress of the process. The anticipated impact of that process is in excess of approximately 1.6 billion rand, relating specifically to third-party customers outside of Sasol. So in conclusion, Madam Chair, with regards to the implementation of the uniform price, as we've indicated and have clearly explained, and also specifically taking into account the reference to a possible formal complaint that might be before NERSA, we implore the regulator to withdraw the consultation document and to start the process anew, and to make sure that ultimately the process as set out in Rule 19 is accurately and correctly adhered to. With regards to the interim methodology, as I've indicated, we will, from Sasol Gas's side, make formal written submissions with regards to the permanent review of the methodology. As was indicated, the due date for that is in May. With regards to the proposal or the suggestion that some sort of an interim methodology is required, from Sasol's side, we hold the position that it is actually unnecessary to adopt any interim methodology, because taking into account the statutory discretion that NERSA has, as well as specifically the rationality test that is provided for in the 2020 methodology, the current circumstances which is giving rise to the concerns addressed in the part of the document dealing with the proposed interim methodology can adequately be dealt with. And as far as the FY23 decision or the 23 application of the 2021 decision by NERSA is concerned, the adoption of an interim methodology cannot change that decision. However, within the powers that NERSA has to monitor and ensure compliance with that decision in the context of the methodology, and taking into account the rationality test that's specifically provided for in the methodology, the ultimate price that will apply for FY23 can submissions that we would like to make from Sasol Gas's side.
Thank you, Mr. Magis, for your submissions, and I'm sure there will be questions arising from the members of the regulator, especially given the earlier submissions that we received from the other participants in this hearing. I would like to then invite the members of the energy regulator to ask a question. If I may ask Mr. Mkhize, followed by Mr. Gumede.
Thanks, Jepson, and thanks to Magis for the presentation. I understand that you had you've got a prepared presentation, but I was hoping that you're also going to talk to the issue raised earlier on, particularly the one of the current pricing methodology not being relevant to the South African situation. I recall well, in terms of the words used, was that there's a disconnect between the international benchmarks and the real world metrics in South Africa. I'll still like you to reflect on that, as well as of the pass-through approach as a simple cost plus approach that should be adopted instead, and looking at the figures that were bandied around earlier on of the 50, and then the third thing that I'd just like to get clarity from you is in terms of the violation of Rule 19 that you're talking about, that sets out the procedure. Has this matter of procedural flaw been highlighted by the Sasol Gas technical team to the NERSA technical team prior to this session? Just want to clarify if there was any interaction that would have reaching the stage to raise these issues, because it kind of limits one in terms of engaging on substantive issues in any event. The functions official principle. I would like to ask you, if don't you consider this as part of the review that would proceed in any event when any authority has put forth a methodology, and because of some landscape changes or major changes or upheavals of any nature, then allows that authority from a point of view of improving it to be able to respond and remain relevant to the various vagaries of the market. So I would appreciate that response. And with regard to Sasol Gas stating that there are no changes that are required by NERSA that NERSA should make. You saying that, what about the echoed by some players? How would you then respond? How should these then be addressed? Because one would argue and say you are actually a beneficiary to that to what is happening now. Hence, then you would not want a change. But when we look at things, we must look at both the downside and the upside from our side, and consider all the players, including South African Corporation. So I'd just like to get your view in terms of that one. I'll leave it at that, Chair. Thanks for the opportunity.
Thank you, Mr. Mkhize. Mr. Comment?
Chairperson, I had not raised my hands because, but nonetheless, I will actually maybe just ask a couple of questions. I had not raised my hand because I think my questions are more related to, to the process of closing on the 16th, because it's more about the future for me than it's actually about the interim and then also this the issue around the uniform price. So that's the reason why I had not raised my hands. However, Mr. Menkes, you actually did hear the questions I posed on the other stakeholder on IGUA. I mean, it would be useful if you could maybe just proffer your own views in terms of that. But the questions that one question that I would pose to you is that IGUA, we are talking about Sasol's customers here. That wouldn't you deem the current issues in the oil and gas space as something that may require Sasol to then, in consideration of its own clients, to then consider the view that has been put forward by your customers that simply says, can you not just take the windfall, but can you consider us here that says the current price volatility is not due to circumstances that necessarily affect your costs, but it's due to externalities, whether those externalities was an excessive winter in the was a winter a colder winter in Europe first, and then perhaps followed by this now war between Russia and Ukraine, but it doesn't actually impact on your costs, and that you voluntarily offer a solution to your customers that take into account that without NERSA necessarily having to come and be seen to be doing something that will be, as you rightly point out, that will fall foul of the principle of funcus officio, for instance. That there are decisions NERSA have made. However, we are talking about your clients here, and as you would understand that in applying that formula, which was done in good faith, but without without foresight of something like this, which has happened in the EU and in Russia and between Russia and Ukraine, that perhaps it is imperative on yourselves as Eskom to voluntarily offer something and not just enjoy the windfall that may actually come out of this. Thanks, Chair.
Thank you very much, Mr. Kumete. I know that it's late on a Friday, and that's why now you're referring to Sasol as Eskom. I apologize on your behalf because you deal with Eskom most of the time. All right.
No, I agree. Apologies, Chairperson, if I made reference to that. It's been a very long day, and and no breaks too. Cheers.
Okay, all right. I'm sorry about that. Thank you very much, Mr. Menkes, for the presentation. Mr. Menkes, I would like to put certain questions to you so that we can have a sense of what transpired out of today's hearing. And what are the solutions as we walk out of this hearing, the solutions to the concerns and the threat, because that threat does exist if one has regard to the current methodology, the pricing formula. There is a threat that if the formula were to be applied as is, obviously it will result in very high price increases. I think we need to, first of all, have acknowledgement of that fact, that there is a threat because of the existence of the formula. And if the formula were to be applied in the same way that you may have applied it from July of last year to date, if you apply it simply as is, then the prices that we'll see will be very high. And I'm sure that it is not something that Sasol would like to see, and the regulator is not something that it would like to see. And as we know that it will obviously have adverse effect to customers and to the South African economy, and in particular also for customers that are in the manufacturing sector, but also other sectors as well. So that is the first sort of acknowledgement and recognition that we must all at least begin from as a point of departure. So the question is, with the existence of this threat, what is there for NERSA or for customers to use as a countervailing power, or to prevent Sasol from applying the price adjustment methodology that we have approved? What is it? If we leave things as they are, we do nothing about it. We need to then ask ourselves, what will then be the worst case scenario if nothing is done? I think those are the things that we just need for the industry that is here, that they need to understand from Sasol. They also need to understand at some stage from the regulator. If nothing is done, what other levers and other powers that could constrain any exploitative price, meaning that a price that is excessively high, as manifested by excessive increases, if the methodology, the formula that is there is applied as is. And because that threat exists and Sasol decides to exercise that mandate, or sorry, the approval, the power that is given, the right, let me not say power, the right that is given to Sasol in terms of our decision, if it chooses to exercise that right as is. And currently there is no other decision that is in place that constrains Sasol from not exercising the default position, right, which is your price adjustment that we have approved. And then Sasol will opt for the rationality test that is there. What is there that in the way that one can look at and say, in the sequencing of how that can be applied, the methodology is clear. If it is clear that you will not so if Sasol now is locked out, that Sasol will then automatically, under these kind of circumstances, if there's going to be irrational outcomes, excessive increases, the methodology lends itself into a rationality test. Is there something that that is leading to that, or it is something that can be, that Sasol can decide on its own? If it has not applied it last year, what will make it apply it in this financial year? I'm trying to just get maybe the way that the methodology lends itself into the rationality test, so that everybody can then appreciate that. But even with the rationality test, what is not clear, and perhaps something that you have not articulated in your presentation, is how this rationality test is likely to prevent the concerns or the outcomes that everybody is concerned about. Perhaps that's also another thing, because this afternoon, nothing has been presented as a solution. Because if you say you may invoke the rationality test, but there is nothing that shows what could be yielded by the rationality test that is in the methodology, or which then, out of the outcomes of that rationality test, if applied, will then address the concerns sufficiently. Just as a demo example that could then put the concerns at bay and allay the fears. We are deprived of that. We are not seeing that. All that we hear is that there is some rationality test in the methodology, but it is not shown the elements of that rationality test, and also the process, how you may land into that rationality test, and what the outcomes will be if then a rationality test is applied. That part is lacking, because then it will bring you closer to responding directly to the concerns that are contained in NERSA's document, and also the concerns that are raised by stakeholders. I'm hoping that I'm making that sequential submission or a query in order for you to have an appreciation of the concerns and perhaps the fact that we are not seeing how the rationality test could then allay the fears and be able to address sufficiently the concerns of potential excessive price increases. The other part that I would like JP to touch on, as you may have heard the submissions earlier that draw heavily on the Constitutional Court judgment. One part that I would like you to at least clarify the position or the articulation of that judgment. It relates to the appropriateness of using benchmark. I would like to hear your interpretation of that Concord judgment insofar as the regulator may use a benchmark approach in coming up with prices, and what are the other considerations? Can you tell us what the legal position is in using a benchmark as well? And this is not to say that a benchmark must just be used, and also to avoid a situation where the benchmark is used coldly and disregarding the actual costs that are incurred, such that then we allow a situation of windfall benefits that are not a situation where a Sasol is not necessarily exposed to some of the factors as well as costs that other international companies are exposed to, yet it benefits by mere fact of the benchmark. So that point is also crucial, because it's the part where stakeholders are talking about the disconnect that is there, and that calls on us to look at it closely. The other thing that perhaps also I would like you to address us on when it comes to the preference that has been mentioned here on the cost pass-through is on the judgment. What are the remarks and the articulation, or at least the position that seems to have been taken by the Constitutional Court in its judgment when it comes to the cost pass-through? And that is in relation to the upper bound, meaning the maximum price, which is the mandate of NERSA. Did the Constitutional Court find that the cost pass-through does meet the requirements of a legal mandate that is that NERSA is in charge of, or in terms of Section 21(1)(p) of the Gas Act, of which mandate 6 that NERSA is supposed to come up with an upper bound of the price. Did the Constitutional Court find that the cost pass-through, in the way that it was done in the other methodology, that it actually meets, and it's simple and it's helpful, it meets the upper bound legal requirement that NERSA should be concerned with? If you can deal with that. The other complication, Mr. Menkes, that you did not assist us with today is when you make mention of this rationality test, and in it you talk about the principle of equitable sharing. Yes, it is in the Constitutional Court judgment. However, I am not sure to what extent the methodology is helpful in terms of articulating the mechanism of applying the distribution aspect of ensuring that sharing of the surplus. Remember, the Constitutional Court spoke about the distribution of that surplus, that when you determine what the cost is, and then you come up with the price, then the gap between the cost price becomes that surplus. But that surplus must therefore be distributed, and that's the word that is used in the judgment, must be distributed equitably. Now, the distribution aspect that will then meet the equitable factor. I'm not sure to what extent the methodology addresses that aspect. And also, I don't think that even if there is an equitable sharing that is considered, that it is supposed to accommodate any excessive increase. If, for instance, the price today, maximum price today, or the price is sitting at 60 rands per gigajoule, now the price is now sitting at, as a result of the surge, is now sitting at 220 rands per gigajoule. So now, is that your submission that irrespective of the fact that the price was at 60 rands per gigajoule and now it is at 220 rands per gigajoule, the fact of the matter is that there is equitable sharing, and therefore we must just be concerned about how we share that gap between 60 rands and 220. I'm trying to see if I understood your submission accurately. And when you say that nothing will be done by Sasol, it will follow the method as it stands in the methodology. And what we should just be concerned about is that the surplus value that is there will be distributed or shared equitably. Is my example articulating your position quite clearly? If we were to do nothing and let you exercise your right as granted in the decision, where you will then adjust the prices because of the decision, and therefore you end up having, say, 150%, I'm giving an example, 150% increase. And so long as then when you decide on equitable sharing, you will make sure that you will be fair to the customer and you will be fair to the supplier, being yourself. Is that perhaps the right interpretation if we were to go along with what you have submitted? Lastly, what I would like to find out from you is the proposal that the prices that existed in July 2021 until June 2022 remain, meaning that perhaps there should not be any price increases perhaps this year at all, and prices remain where they are. Do you think that it is something that Sasol can consider in dealing with things in a reasonable manner and avoid any detriment to the industry and any detriment to its reputation and any detriment to customers? Do you think that it is something that Sasol can consider? And is there anything that Sasol believe will be harmful if such a proposal were to be entertained, let alone the legalities, let alone the mechanism in which such outcome can still be can be arrived at, and leave the legalities about NERSA not being able or allowed by law to change its decision or something, let alone because maybe if there is a mechanism of trying to achieve the same results, but in a much more sound legal way, and there is a mechanism that could still land us on the same outcomes. Assume that is the case, which this means that there will not be any increases this year. You forgo the increases in prices because of the circumstances. Is Sasol vehemently opposed to such a proposal, and what will be the reasons? And such reasons, if you could try not to rely heavily on the issue of not being able to review our own decision. Then the last thing that I would like to find out is the consideration if anything else fails in the interim, and there's a threat of these high prices, and there is an uncertain situation, an unknown outcome of the rationality test. All of these things being there in our minds, and nobody knows what's going to happen. Then the other alternative that has been put forward is the suspension of the methodology. To suspend the methodology, and in that way, one is moving away from then suspending the maximum price decision, which is an administrative action. So if NERSA then moves away from suspending the maximum price decision because it's already an administrative action and it cannot review its own decision, but given the problems or the challenges maybe with the methodology, if nothing else can be considered in the interim, then the methodology gets suspended so that one then avoids the detrimental effects of it being used as such that it results in absurd outcomes. What will be your take on that? What will be your submissions on that? If you could kindly consider that. we will have the sort of a second round just on the other aspect regarding section 4D. I would like to just confine the questions on this, but we'll be out of here 20 to 6. Thank you.
Right, that is quite a challenging array of questions. I think if one starts at the suggestion of suspending of the methodology and the like, I think just purely from a technical and practical point of view, the suspension of the methodology will, with regards to the existing decisions that NERSA may have given in the respect of Sasol Gas or any other traders, have no legal effect. It will probably influence any future applications that any trader have to bring, because I think again the same principle of the fact that the existing decision is a valid decision and that the decision maker is functus officio in respect of that decision, that remains to apply. Taking into account a number of the issues on the table.
Sorry, JP. If the methodology is suspended, just hold on. If the methodology is suspended with immediate effect, will that not affect? Will that not affect any adjustments that are supposed to be calculated based on the methodology as from July 2022? Will it not affect that if the methodology is suspended and that decision is taken in June? I just want to get to make sure that I understand your response.
Yeah, no, it will not, because the basis on which the decision is made is contained in the decision itself. The decision doesn't require the methodology in order to give effect specifically to the method that's approved in paragraph 2D of the decision, because the method is explained in there, and the data sources, etc., irrespective of whether the methodology applies or does not apply, I would submit, and this is obviously a question that we could explore further and give further submissions on, but just I think as a matter of principle that underlying basis on which the decision was taken, the mere fact that is taken away or is amended will not affect the content of the decision itself, because the decision, and I think that principle was fairly clearly confirmed in the Constitutional Court, and that is that the adoption of the methodology and the making of a maximum price decision is separate administrative decisions, and they are independent from each other and independently reviewable from each other. But that is something that one can obviously get more specific legal advice on. I think just taking into account a number of the questions, and I will come back to the detail in a moment, but I would just think from a principle point of view, one has to take a bit of a step back and take into account that the powers that's provided for in the NERSA Act and the Gas Act, and specifically the powers that is afforded to NERSA to approve maximum prices, is linked to the circumstances in the market, and specifically the fact that there may or may not be inadequate competition existing in the market, and therefore the approval of the maximum prices that NERSA places into the market, which is let's call it suffering from the inadequate competition that Section 21(1)(p) talks about, is basically it's NERSA's role to put that competitive market characteristics back into the market. And the concerns that we are talking about are real concerns, and price volatility and price spikes and price troughs over time in competitive markets are real characteristics and real elements of a competitive market. And in order to try and come up with a, let's call it a method or a methodology for determining maximum prices that totally ignores the nature and the characteristics of the competitive market, that the method or the methodology is ultimately aimed to mimic or to reintroduce back into this market with its inadequate competition. I think that is maybe the wrong path to try and go down to. And maybe 2 points to add to that. The fact of the matter is that if one ultimately ends up in a method or a rule that is adopted by the regulator that is purely a piece of subordinate legislation, which just automatically determines what the maximum price is from day to day or from month to month, that totally ignores the role that the regulator ultimately has to play, taking into account the objectives of the Act as set out in Section 2 and the weighing off of the interest between the participants in the market. So unfortunately, it is true that the regulator has quite a difficult task and a difficult job in coming up with a maximum price approved for a particular licensee, in our case Sasol Gas, which is reasonable, rational, and is at such a level that it is acceptable and workable in the market. But ultimately, that is a task and a responsibility and a mandate that NERSA cannot absolve itself from, and that NERSA cannot design methods and methodologies and policy documents that will ultimately take away the discretion that it is encloaked with in terms of the establishing legislation by which the regulator is established. Because that in itself, if you end up in a situation as a regulator where you adopt internal policy documents that fetter your discretion to such a level that ultimately you are taking away decision-making power that the legislature has afforded to you as the regulator, then that in itself is a reviewable and illegal administrative action. So unfortunately, the regulator is within the context of the difficult circumstances that we as the supplier, the customers as the users, and the regulator as the economic regulator in the market are all confronted with. Ultimately, the regulator in terms of the Gas Act and the NERSA Act have to take the decision and have to determine the maximum prices that's appropriate, taking into account the inadequate competition that Section 21(1)(p) talks about. So if one then comes to the question about what is the connection to the South African market to international markets, from a Sasol Gas point of view, and I think we've stated this view repeatedly in our engagements with the regulator as well as in our price applications, as far as we are concerned, gas and natural gas is an internationally traded commodity, and therefore the fact that this commodity moves between international markets make the use of international benchmark pricing appropriate. Certain of the customers that we deal with are also manufacturers or industrial companies which compete in international markets. And in a circumstance where we find ourselves at the moment, where in South Africa customers are enjoying of the lowest gas prices internationally, apart from the downside and the adverse impacts that the certain of the customers are talking about, there is also a considerable advantage to customers in operating within this market with the very low energy cost. When it comes to the specific price levels and the price level of 50 Rand that was quoted, etc., etc., I'm not in a position to answer in detail over the entire period the specific prices that applied from time to time. I do think personally that the way in which it is submitted and was submitted appears to be somewhat of an oversimplification of the situation, but I think as part of our further submissions to the regulator, we would surely be able to point out how the maximum prices as well as the actual prices over the different periods, i.e. the period before 2014 and the period thereafter, have moved, and we will make more detailed submissions to the regulator on that. With regards to the question about the violation of the rules and the raising of that, in the written submission that we made in response to the consultation document, we definitely addressed the issue, and informally in discussions earlier between members of the technical teams on Sasol side and technical members of technical team on the NASA side, we have certainly indicated that we think that the publication of the uniform price consultation document was unfortunate and not entirely appropriate. And as I say, in our written submission to the regulator, we've made exactly the same arguments as I've set out in the presentation today as well. With regards to the question of the, whether the regulator is functus officio, and whether it is possible for the regulator to review and refine the methodology, I think it's important to understand that the legal principle with regards to the price decision that was taken in 2021 and which has a very specific period of duration, and for that period of duration it constitutes a final decision by the regulator, and therefore that decision by the regulator is not open for amendment by the regulator itself. It can only be overturned through the legal processes that may or may not be ongoing. As far as the methodology is concerned, I think I did indicate in the presentation that apart from NASA having an inherent power to from time to time adopt appropriate policy documents to guide their decision-making processes, etc., the methodology itself in paragraph 12 of the methodology confirms the fact that the methodology will and can be reviewed from time to time and can be reviewed if circumstances dictates. I think that the position that Sasol Gas takes and that the licensee is putting forward is linked to the comment that I made earlier, in the sense that there's a fine line ultimately for an administrative body to toe with regards to the adoption of policy documents, because to the extent that those documents ultimately limits and fetters a statutory discretion that is provided to that administrative body, then there is also legal consequences that may stem from that. So I think from Sasol Gas's side, we clearly understand and we recognize the regulator's powers in reviewing its policy documents and the guideline that the maximum price methodology is. But in addition to that, we submit that refining or limiting the mechanism through which the maximum prices are determined with reference to the international benchmark prices, taking into account the fact that the regulator has the statutory discretion that we've referred to, and specifically also in line with the directive by the Constitutional Court relating to the equitable sharing of surplus economic value, the fact that that rationality test is already contained within the methodology provides the regulator with enough of a mechanism to deal with these upset situations, both on the top end of the economic conjuncture, but also at the bottom end. Because if one sets the rationality test, and the Constitutional Court talks of the cost of the licensee as the floor in that regard, and then clearly confirms that the role that NERSA has to play in setting the maximum price is to determine the maximum or to determine the ceiling, which is clearly above that cost level, and then employing the rationality test as NERSA has included in the methodology, provides it with a mechanism to ultimately determine, well, if my international benchmark formula spews out a price which is at an excessive level or an unreasonable level, then this rationality test and the obligation to ensure that the maximum price results in an equitable sharing of surplus value affords NERSA the basis on which to determine a maximum price that is at an appropriate level. With regards to the questions on the longer-term process and the longer-term review of the methodology, I would like to reserve our rights, if I can put it that way. And as part of our formal submission on the second part of the consultation document, we will deal and we will submit Sasolgas's views with regards to possible mechanisms if and with regards to the longer term application of the methodology. And then with regards to the question about the windfall or the fact that the question that was posed about the how to deal with a threat, I think the first point to make in that point is that there may be a bit of a difference of opinion here between the position that Sasolgas is putting forward as the licensee and the viewpoint held by the regulator, and which ultimately leads to the consultation document. And that is this perception of a threat that the benchmark methodology or the benchmark price formula is to be applied as is without any further consideration. From our point of view, we think that is actually not a real threat, and it is not a threat that really exists, because from a legal point of view, the methodology has to be approached within the entirety of the mechanism that is dealt with and which is prescribed in the methodology. So you can't stop only by determining an adjustment or determining the maximum price in accordance with the formula that is provided for in the methodology. There's two further steps that have to be taken into account. The second one is the rationality test, and that rationality test has to take into account the difference between the acquisition cost and the ceiling set, and then there is a comparison of the international benchmark price that the formula yields, and then there is the power of NERSA to determine within the band between the floor and the ceiling, where should that maximum price lie? So the threat of that formula being applied without tempering or without control, the way that the methodology is set out actually prevents that. And when NERSA ensures and reviews the compliance by the licensee of with the price decision that was taken, then obviously NERSA has to take that into account. And in any event, if a new maximum price application for a different period comes before the regulator in terms of the mechanism in paragraph 3.1 of the methodology, then again, all three of those steps, the third one obviously being determining the trading cost element, all three of those steps will have to be taken into account and will have to be applied by NERSA. And to the extent that the applicant is putting the maximum price before the regulator in such an application, it's incumbent on the applicant to put the necessary factual support for the price before the regulator in order to enable the regulator to apply all three of those elements. I think the question about the actual price level and where the actual price level should come out, I would not be in a position to respond to that. The discussion and the topic for the discussion today is the methodology, amendments to the methodology, and in our view, whether such amendments are required. When the discussion about the actual price that is to be applied within the FY23 time frame, or a actual price to be applied for in respect of, in Sasol Gas's case, FY24, that is something that obviously is to be discussed within the appropriate forum where those engagements between the regulator and ultimately, if required, a public engagement is taking place. So I'm not in a position to comment on a specific price level going forward. So I think I've in the comments that I've made, hopefully addressed most of the questions that were raised. But to the extent that from our side, we also need to, or are afforded the opportunity to submit further written submissions in response to these questions, we will also do so within the 7 business day time frame in respect of particularly the interim methodology, and to the extent that it relates to the longer term review of the methodology, we will include that in our submissions in that regard. Madam Chair.
Thank you very much, Mr. Menkes, for your submissions and clarifying Sasol Gas's position with regards to the intervention that has been taken by NERSA, and also seeking the industry players' input with regards to the initiatives that NERSA has taken. We thank you for that, and we also look forward to the additional or supplementary written input with regards to some of the points that we have put forward to you, some of which you have also indicated that you may want to perhaps obtain a legal opinion, for instance, on the issue that arose from these public hearings, which is the the proposal, or at least some of the views stated regarding the suspension of the methodology. You stated your views, but you said you would also want maybe to get a legal opinion. So I'm just indicating that this is one of those responses you may want to supplement your response and provide that response within the next 7 days. And I emphasize that subsequent to a hearing, we only afford stakeholders 7 days because we would have done the initial period of comments for 30 days. And once then there is a public hearing, our rules are very clear. We can only allow that any issues that are not responded to adequately, that stakeholders submit their inputs in the next 7 days. I hope that is clear, and that is the 7 days that is afforded to all stakeholders if they haven't responded to all the questions. So thank you very much. You may also provide the additional input. We will also, I think the team will provide clarification insofar as the complaint is concerned, whether that complaint was not, finally lodged officially. They will clarify that position, and also will take your proposal as to how to deal with some of the procedural concerns insofar as the complaint is concerned, because I understand that as you've articulated the procedures quite clearly, there will be a complaint procedures. So it must be treated differently from a market-wide inquiry or investigation in terms of Section 4D, because that will be an initiation by NERSA. But when it's a complaint, I think the procedure for complaint will be slightly different in terms of affording the respondent an opportunity to respond to the allegations prior to making any findings. I understand that. And the team will interact directly with SASOL with regards to that aspect. I'm not sure if you wanted to say the last or the final remarks, Mr. Menkes, before we wrap up and close the hearing.
Yeah, I think maybe just for the sake of clarity, I think it's important that even with regards to a so-called industry-wide or NASA-initiated inquiry, specifically in the case of the uniform price, where there is conclusions made by NASA that directly affects a specific licensee, the rules of as set out in Rule 19 is very, very clear as to how that process should unfold. And it remains our position that independently from the issue raised around a possible formal complaint, that those procedural requirements have not been met. So I just wanted to make that 100% clear. But thank you for the opportunity to make the submissions to the regulator this afternoon, and we're looking forward to the continued engagement with the regulator in the spirit that the discussion took place today as well. Thank you for that.
Thank you, Mr. Menkes. Yes, the point we take on with regards to Rule 19, it is in order because the regulator will investigate, and unfortunately the scheme of our act is such that we investigate and we also have powers to adjudicate. So we also have some adjudicative powers as we have investigative powers. So it is in order that we then afford the party or the respondent an opportunity to respond to the allegations, if there are any allegations, before any final findings are made. That is in order. We get that very clear. We will, but the matter has not come before the decision makers, but it is something that obviously the management will take care of it. The point is correct, and I hope that also in the 7 days period, issues pertaining to your submissions insofar as rationality test is concerned, you will amplify them, as we indicated that you are talking about something that we have not seen what the results are and how it will address the substantive concerns that are raised by the industry, of which concerns also are contained in the NERSA document that is the subject of today's hearing. So I'm hoping that you will also take the opportunity to address that aspect, and also the extent to which rationality test, as we have it, seeks to deal with or take into account cost considerations, so that there is a cost price, a difference that is contained therein, that is considered, and the extent to which it might actually also lend itself to any benchmarking price. And if you can address some of those concerns which are linked to earlier statements that are made, we'll look forward then to that additional submission in response of those questions in the next 7 days. Thank you very much, Mr. Mendes. All right, ladies and gentlemen, we have heard all the players today and the presenters that have come forward to share their perspectives and also provide some useful information, useful guidance, and they are also going to provide with some additional expatiation on the issues that they've presented before us today, which we welcome. And we are not going to rush our decision on this matter because we want to do things right and be certain about any position that even the team as well as the subcommittee will put before the energy regulator for the final decision. So it is important that we look carefully at this matter, and therefore we will wait also for the other submissions in relation to the long-term methodology that might actually take a different approach depending on economic considerations that need to inform such an approach, and also what is currently happening in South Africa in terms of in terms of gas and the new entrants and the likelihood of having LNG flowing into South Africa, and how that will play a role even in the approach of determining the price of gas going forward. So those are some of the things that perhaps the long-term view may have to delve into. So I would like to thank you for taking the time to observe these public hearings, and also for the presenters to take the time to prepare presentations and prepare legal and economic arguments on both presenters that came before us today. And we really appreciate your time and the robustness of the engagements that we've had today. They will certainly assist us in looking carefully at the matters that are before us, which are quite complex. And I would like to also thank my colleagues who have assisted in asking the right questions in today's hearing, as well as the team from NERSA that organized this public hearing. The hearing is adjourned. The stakeholders will be informed of the next hearing in relation to the next or the second part of the refinement of the methodology in trying to get an understanding of where we should be going as the regulator in regulating the gas prices in South Africa. And being informed by our own circumstances and what we would like to see in the market. So at this point in time, members, I would like to then say that enjoy your weekend. I'm sorry for keeping you until late on a Friday. Mr. Gumede, I'm sorry that Walter had to not accommodate any break. I think he thought that because we only have two stakeholders, we will be able to finish very quickly. Unfortunately, the issues are very sensitive and they really need more time. Thank you all, and the hearing is now adjourned. Thank you. Have a good weekend.
Thank you, Chairperson, members.
Thank you, Chair. Thank you.